Yes.
For 10, because settlement has already been done 2 months back.
What has been done? The learned counsel, Mr. J.I. Bodnia, the learned counsel appearing on behalf of the petitioner, submits that the petition has become infructuous, and as such, the petitioner would not like to further proceed with the petition. Accordingly, the petition stands closed. As it had become infructuous, the model, if any, stands repeated. What happened to your yesterday's matter?
Side effect was not issued. Side effect was not issued.
Not received.
Not issued. I informed what master yesterday only.
तो item की बात सुन. हाँ? Great. Now, Mr. R.S. Mistry, the learned counsel appearing on behalf of the petitioner, as well as the H. Sharma, the learned counsel appearing on behalf of the state of Assam, district administration. So, the grievance of the petitioner hearing is that the petitioner has not received a certified copy of the
Order, my lord. Side effect copy of the order in this case, I forgot I provide.
certified copy of the order passed in this case number so and so. And as such, the petitioner has approached this court. Mr. H. Sharma appearing on behalf of the district administration. It is a mutation order.
Yes, my lord. Yes, my
Submits that the petitioner, that if the petitioner files the said, submits an application. Nowadays, it is to be done electronically, yeah? The certified copies. Submits that, and if the petitioner submits an application in the portal seeking the certified copy, the same, the petitioner would obviously be, if the petitioner would obviously be provided with the said certified copy. Which, taking into account the above, the learned counsel appearing on behalf of the petitioner submits that the petitioner would submit an fresh application for obtaining the certified copy of the order passed in this case number so and so. It is observed that if the petitioner submits such application in the portal seeking the certified copy, the concerned authorities shall issue the certified copy of the order with the above the petitions that exposed. Yes, now please.
Item number 6, my lord. Item number 6, my lord.
Hmm.
Here, my lord, business passed away, my lord. He passed away in sometime 2022. Yesterday only while I had to contact the person, we came to know he has passed away, my lord. My lord,
What is the matter about?
regarding my restoration of Enlo Patta, my lord. In conversion of Enlo Patta into my wedding Patta. There were total 3 kattas.
Restoration of the inval patta. Then you have to file an application for substitution.
I'm paying for 10 days time.
Mr. R.S. Mishra appearing on behalf of the petitioner submits that the petitioner had expired. And as such, there is an requirement of filing an application for substitution of the legal representatives, taking into account that the cause of action, taking into account that the right to sue survives upon the legal representatives of the deceased petitioner. According to this matter, after such application is filed on behalf of the petitioner, such applications are filed.
Engaged
Is
counsel,
this-
12 and 13.
What do you want?
Engaged counsel, Mr. B. Bora has some.
Who has problems?
B. Bora.
Ebola. 12 and 13. 13 is somebody else. He's not weak. 12 and 13. What is the matter about?
Item number 13, Mr. Bora is the petitioner.
What is the, what is the
Item
matter
number
about?
10 is a private residence. Yes, illegally constructed building for which the land towards the road towards the petitioner's land became narrow. Which petitioner has filed complaint before the Noga Development Authority.
We'll take it up when the matter reaches. Don't mention this matter, these are 2015 matters. You want this matter to have a decade anniversary?
May fix a date after vacation.
Absolutely no, we'll see when the matter reaches. In time of the vacation. Yes, what is this, Mr.
The written instruction have,
What is your instruction?
she's also online here. The officer concerned, we have joined on 21st of September. And from 27th to 1st of October, he was out of station. Already, he has allowed, the petitioner can go and register there.
Let the petitioner go and get it registered, because this is a issue which I don't want. Because,
If you have submitted application might have done 39 also.
no, it's okay, the officer was not present. So you go there, they will register it.
Yes.
Your lawsuit order is 27 9. Lawsuit order is order dated 27 9.
27. It's okay. Mr. District Commissioner, you are there?
Your Honor, I am here, Your Honor.
Huh?
I am here, Your Honor.
Yes, sir. You see, here, this court would not like to go much into this controversy because it would portray a very poor picture. So better you carry out the registration, ask your sub-register to get the registration done.
Sorry, Your Honor. Thank you.
Heard Mr. H.R.A. Chaudhary, the learned senior counsel, assisted by Mr. M.A. Chaudhary, appearing on behalf of the petitioner. He now appears on behalf of the state of Assam. The senior government advocate appears on behalf of the state of Assam, as well as for the district administration. He submits that pursuant to the order passed by this court on 27/9/2024. An email has been received that on account of certain government holidays and the officer being not present, the registration could not be carried out. However, the petitioner can visit the office and the deed could be registered. In that regard, he has submitted before this court an email issued by the BC Karimganj dated 3/10/2024, which is kept on record and marked with the letter Y. This court have also heard the district commissioner, Karimganj, who was present through the video conferencing link and had submitted that upon the petitioner visiting the office, the deed of sale would be registered. Taking into account the above, Mr. H.R.A. Chaudhary, the learned senior counsel, submits that the petitioner would not like to further pursue with the instant proceedings. He, however, submits to proceed with the, however, he submits that in the circumstance the said deed is not registered, the petitioner may be granted the liberty. That is not necessary.
RDR also not mentioned. I don't like. this.
Taking into account the above, undertaking being given and document kept on record and marked with the letter Y, this court closes the instant petition. These matters require urgent disposal.
One, two, and 23 were also directed to the district. Our counsel from the outside is, that material item from, compounding the offense.
79 too. Yes.
Maybe taken item number, along with item number 23.
That I have fixed at 2. Okay, 1 and 2.
Three. On item 3.
Yes, madam, your matter will be taken up at 2, along with the other matter.
Obliged, your lordship.
Yes. What is this?
I have challenged the department.
An order of 29/4/2023. Where is that?
Page 169.
What does it say?
That I have,
5 years due to furnishing false information about manufacturing facility. Is blacklisted from all tenders of so-and-so for a period of 5 years from the date of issuance of this letter. In addition to above, your security will submitted. Your purchase order will also be forfeited with the financial. Yes, you were issued notice, where you issued notice prior to this.
On the support notice, those two support notice were issued. Regarding that, I have my test, the devices, medical devices claimed to be there by the respondent. That these are surgical items and tested negative as per medical devices. 1940. And for taking that, I will text you this honorable court to annexure 1.
And Mr. Counsel, who has issued this? Who is paying for the health service? Huh? You are paying for the health service,
National Health Mission. National Health Mission, this was number 2 year.
National Health Mission. They have done it. Assam Medical Services Corporation Limited. What is this? Who is paying for them?
Okay.
Who is paying for the Assam Medical Services?
Case number 1. Order dated
It's a government of, the government in, undertaking. How do you say so?
earlier one writ petition was also filed challenging the so-called notice.
That's because earlier this file is different. I'm not on that. But the only thing is I'm asking you that where have you mentioned that it is a state?
Only with the so-called notices. And department notice.
Where is the show cause notice?
Proposed notice is
You came earlier before this court.
Yes. During pendency of that petition, they have a department.
Huh?
Whereas there was a specific direction. Kindly there is the page number 164. Order dated 22 to 23. Item 3, the Senapati Learned Counsel for the petitioner. In the case of the petitioner that the pursuant to the tender process for supply of surgical consumables, the petitioner was allotted a work on 5/1/2019 for such supply. It is in the case of the petitioner that almost the items to be supplied in the roll bandage, while the petitioner claims that the quality of the product of the supply matches with the quality given in
Where
the
is the
tender.
tender? Tender is where?
Tender is page, annexure 1.
You submitted in pursuance to this tender.
Yes. 841.
For entering into a rate contract from empanelment of manufacturers to supply essential surgical consumable chemicals. This has been issued by whom?
Respond number 2.
National Health Mission.
National.
Now, why the order is being passed by this managing director of Assam Medical Service Corporation Limited
So they are the controlling authority. They are the controlling authority.
of National Health Mission?
Yes.
No. No, it can be.
Good.
Where is anywhere the involvement of Assam, this organization? Yes, where is Mr. B. Gogoi? So you know anything about this matter?
Yes, sir, but the question is, on reopening of what I'll give the instruction and please, because you're going to be given.
No, I'm asking you, do you know anything about the matter? The question is, how the notice, a tender is issued by the National Health Mission. Isn't it? If it is issued by the National Health Mission, what is the role of the Assam Medical Services Corporation Limited in the tender? And if there is no role, why they are passing any order in respect to this? Does this order have any connection with the tender? If it
In
is
respect
the
of the
connection,
tender, they have a department.
Huh?
In respect of that tender, they have department. Respond number 3.
no. I'm asking you, how does this response number 3 has a connection with response number 2? Or does this response number 3 has any connection with the tender? If they have no connection with the tender, then who is it to issue this type of orders?
So the surgical items were tendered by the respondent number 2. It was issued for the by the respondent number 2 for the surgical item and consumables. And regarding that, they said that on the analysis by the drug controller, Kolkata Central Drug Authority, the report tested negative and these were failed. These items were failed. And they have issued me first so-called notice to so-called notices asking me that your such those items were failed and explain me why the penalty should not be imposed. Thereafter, they have debarred me. During pendency
This
of
is the debarring order 29/4/2023.
Yes.
This is what you are challenging now. Yes, Mr. B. Gogoi. What is the connection of response number 3 to the response number 2?
It's a new entity now.
Huh?
Yes, but earlier, these medicines are procured by NSM only. Now, this new corporation has been instituted by the government in order to procure all the medicine and all, for the entire state. So it is now shifted to this particular hotel.
But he has no business out there in respect to this tender.
Tender process, yes.
Then if tender has no business, that in respect to the tender, isn't it the NHM who has to pass the order?
Workload of my lord, supply and all has been now shifted to this office.
When?
That I can place, my lord. This, it's now, my lord, this corporation is there.
May have been. Now,
Yeah.
now it is so. But the question is, at that point of time, if he has no link.
Well,
My
yes.
question therefore is, if response number 3 has no link with the response number 2,
It's a
in
independent-
respect to the
not a-
tender in question, can the response number 3 take an action on behalf of the response number 2? That is my specific query.
My lord, that part where, what is the, my lord, extent of, my lord, authority that has been given to the respondent of three, I will have the instruction on 21st. But, my lord, the case that has been projected by the petitioner, that's actually, that's not the case. In fact, my lord, the earlier SOCOs was issued, where, my lord, some subsidized, my lord, products were submitted to the, were supplied to the NSM authorities. For that, the SOCOs was issued. So, for instance, the issue
So
of
cause
it is
notice
concerned
issued by whom?
by NSM at that point of
That
time.
is what I'm saying. So cause notice is issued by NHM. If it is so, why the order is being passed by this authority?
Just separate, that's what I want to point
Did
out.
this authority issue the so called?
Lord, we will see. Here, my lord, this authority, my lord, after it, my lord, it was established and the, my lord, entire work of supply has been transferred to this particular authority. And inspection was conducted in the factory premises of the petitioner. For that reason, this, my lord, requirement notice is given, not for, my lord, supply of that.
But
vendors and all.
did this authority issue the so cause to the petitioner?
This one, page number 125.
My lord, yes, since then,
Where?
page 125, Medical Service Corporation Limited. Thirteen to 2020. AMS here. In fact, my lord, I have come across cases where.
And what is your reply? Where is your reply?
Regarding that suppose notice. At page
Yes, Mr. Counsel, you are not prepared. Page.
page number 143.
140.
As per schedule F2, they have a department. They have tested the devices of schedule F2, which is not applicable to the petition.
This is your reply. That on the basis of the test.
Test.
Which test should have been incorporated? That is your case,
Right.
which is similar to the section 28(3) of the Drugs and Cosmetics Act.
Now, peruse the page number 87, Annex 13.
Now, the test which is being done, this comes under the Drugs and Cosmetics.
Yes, they have tested the item as per drugs and cosmetics.
Now, have they initiated any criminal proceedings?
No, ma'am.
No.
Till date, they have not. The page number 87.
So 1 year has gone. You have another 4 years.
No, they have got me in, yes, one year.
Huh?
Yes, ma'am. one year.
Lordship may see that focus notice at page 125 and the requirement notice at 169. The tags are not same, that's what I want to point out. Lordship will see, my lord, for the moment the so called. It relates to, my lord, supplying of substandard, my lord, product or items to the NSM authorities or to this particular authority, my lord, that's one now. Now, Lordship will see, my lord, 169. May I read the second paragraph? Your company has agreed all the terms and conditions of the tender and submitted annexure so and so against the tender. You have submitted annexure so and so with a declaration that if any information furnished by you proved to be false at the time of inspection, the non-compliance of condition as per Schedule M of the Act, the tender inviting authority may forfeit your EMD, performance security, and blacklist you, your company for a period of 5 years. Declaration, Annexure 2 and Annexure 7.
So if those so-called notices have no connection with this order,
They
then
might not-
wouldn't this order therefore be bad on the basis of principles of natural justice?
Might be, my lord, for this particular department, my lord, there was a separate so-called notice, because in the third parallel also, you will see.
I had not received any.
No, I will have the inspection on 21st. Lordship, you will see the third para. In this context, it is to be mentioned that so-and-so, subzone so-and-so has shared the joint inspection report of your manufacturing unit. Not about sample matter. Conducted by so-and-so and the drug control department. Wherein adverse report has been highlighted with respect to your manufacturing facility. And as such, it is clearly established that you have submitted wrong or false information about your manufacturing facility. For that reason, my lord, along with the tender documents, the documents that has been submitted by the petitioner regarding the, my lord, factory premises,
So you have acted in terms with Annexure 2 of the tender submitted by him. You have done it, but before doing it, so-called, no idea.
have the inspection
No,
on
I have not
21st.
received.
And what is your case? No so-called. That is your case. All along, I was asking you from the first moment, that is,
On 21st, my lord, immediately.
And during the inspection, my factory was under renovation. No, work is going on at that point.
okay, that is another aspect. You could have very well replied to that effect. If you had issued a show cause. But that was not given to you. That is your case. Heard Mr. Slan's plan. If you notice, making it returnable on. Otherwise, I would have stayed it. But the fact that I am not going to stay for one simple reason, why you have woken up after 1 year, 5 months.
There was reason that the owner, one of the partner was suffering from the dialysis. He was undergoing dialysis due to the kidney problem. And he was frequently taking.
But is he not doing any other business all this while? They have stopped doing business? No, have they stopped doing business? Okay, issue notice making it returnable on 6th of November 2024.
1%.
Mr. B. Gugoi appears on behalf of the respondent numbers 1 to 6.
When it is settled.
Huh?
Okay.
7, 8, and 9 who appear? Mr. So-and-so appears on behalf of the respondent number 8, 7, 8, and 9. Taking into account that all the respondents are duly represented, extra copies of the petition be served upon the learned counsels appearing on behalf of the respondents during the course of the day. The petitioner herein have challenged the order dated, the communication dated 29/4/2023 issued by the managing director of the respondent number 3, whereby the petitioner company have been blacklisted from all tenders of Assam Medical Services Corporation Limited for a period of 5 years from the date of issuing the said communication. In addition to that, the petitioner's security deposit submitted against the PO/POs issued to the petitioner would also be forfeited as a financial penalty. The case projected by the petitioner herein is that the said order Impugn order dated 29/4/2023 is an order passed without providing a due opportunity to the petitioner, inasmuch as there was no such show cause notice. The learned counsel appearing on behalf of the petitioner submitted that two other earlier show cause notices were issued, which had no relation whatsoever as regards the subject matter of the impugned communication, didn't it? On the other hand, Mr. G. Gogoi, the learned counsel appearing on behalf of the respondent, number 126, submitted that the petitioner have approached this court after more than 1 year, 5 months. He further submitted that he therefore submitted that the instant petition suffers from delay and laches. In addition to that, he submits that he will have to also obtain the necessary instructions as to whether there was any show cause notice issued prior to passing in respect to the subject matter of the impugned order. Taking into account the fact that the petitioner has approached this court almost after 1 year, 6 months, almost after 1 year, 5 months, this court is not inclined to pass any interim order at this stage without providing an opportunity to the respondents to submit their stand by way of an affidavit. Accordingly, this court, the respondents number 1 to 6 are directed to bring on record their stand by filing an affidavit on or before 28th of October 2024. The petitioner, if so advised, would be at liberty to file any reply thereafter. On the next returnable date, this court shall would consider the petition would consider as to whether any interim order can be passed on the facts so placed. Oh, yes. I fixed the date, 6/11. You file your affidavit. Yes, Mr. D. Chakraborty, what do you have to say? What is this matter about?
But petitioners are the residents of
Holding elections.
election, my lord, and I pray for an interference from this honorable court against the arbitrary enhancement of taxes
Why both?
reflected
No,
at
first of all, Mr. D. Chakraborty, why are you bringing these two aspects together?
my lord,
One is election, the other is.
my lord, election and enhancement, why cumulatively before your lordship is because of the fact that had there been election, which is a mandate as per the provisions of law, constitution as well as law, there would have been an elected body. There would have been representative of the people of the different wards. And the procedure would have been as per section 68, so far enhancement of taxes are concerned. But here what has happened is respondent number 6, in his own whims and caprices, he has.
Now tell me, Mr. Datta, what will happen now? Now you are going to have a Silchar municipal corporation.
Lord, your lordship, aware, your lordship has passed an order. on 24
Now what is going to happen?
Now, the indication by learned friend is that as if we are not doing anything. On the other hand, your lordship has seen the people of that area filed a challenge that particular notification.
Now the
Now,
elections will be
going ahead for all
held.
that. Otherwise also, I have.
Apart
from there, the lordship kindly see. My lord, the joinder of two separate causes of action, whether writ petition is maintainable. That is also to be looked at.
No, it's okay. Therefore, the elections will be held now, I suppose. Yeah, I think by December, they are thinking of holding it.
Right,
That
right.
is what the submission.
that can be taken care of with that.
Okay, done. Next. what
And
is-
then, my lord, now, as of now, my lord, the grievances, so far the enhancement of the taxes are concerned. Now, if your lordship kindly,
Now you are going to be corporation.
my lord, that of course is a non.
We'll be having a new act.
Absolutely, the act of 2020.
You should be happy.
Absolutely, my lord, but as of now, my lord.
Advance Act from 1956. 70 years, new act, new progress.
My lord.
They are going to follow 243Q. Yes.
My lord, so far, the present act which is in vogue, so far as section 68, if your lordship kindly, has a look at section 60.
Where's the increase? Show me.
The increase is at page 7. This is without
Page
page 7, my lord.
7?
Yes, this is my pleading. Page 7 at page 13. Now,
There's no order passed.
no notification. The people are going over there to pay taxes, the prevailing rates which were
Page
there.
7.
Yes, paragraph 7, page 13.
Paragraph 7. Yes.
And this has been,
Has enhanced the water tax from 125 to 300. That apart rates of 19 pounds pertaining to Iman. The enhanced period. But there is no order.
there is no notification. People, when they are going for paying the taxes, they are being apprised from the counter.
In the local newspaper 25/6.
Has been annexed, my lord, at page 33.
Page
Page 33 to 35 is the translation. And the vernacular is from
Who
page
has written this?
36. to
There is
page
no
36.
elected board. Somebody has written it.
Your lordship kindly issue. This with the approval of the director.
Steps to be taken to realize the rates and fares estimated in the budget to include the financial no remission. Budget estimate is approved on the strength of the rule of CPA. All ULBs without some accounting. Numbers. So you had made a budget estimate for 2024-25,
Correct.
and that has been approved by the director.
Exactly.
This is being done in terms with that 20, what is that provision?
229.
Huh?
299.
299B.
Now, my lord, if I draw your
Apart from that, your lordship kindly, the chemical costing rupees 8 rupees per kg has become now 20 rupees per kg.
Which
Even
one?
then, my lord will have
What
to come up
notice?
with a affidavit to reply on that.
What is the notice? What did you say?
My lord, the chemical, my learned friend is saying the water tax have been enhanced from 125 to 300. But that is after lapse of more than 4 years. In the meantime, what happened? The cost of chemical for purifying the water, earlier it was rupees 8 per kg, now it is 20 rupees per kg. Unless it is.
So you are asking this court to decide as to or exercise judicial review
my lord.
on the aspect or the wisdom of the authorities to fix the rate.
Statutory, not on that, not in so far, my lord, interference of this court in fixing of the rate is concerned. It is only for statutory compliance of section 68 of the Assam Municipal Act 1953. Section 68. 68 of the Assam Municipal Act, which lays down a procedure. Now, my senior colleague has placed an approval from the directorate. I have made the directorate also a party in this case. Now, can this be the process? This is my humble contention. Can this be the process? Can section 68 be given a total go by in adopting this process in placing a budget by respondent number 6, who is an appointed officer of the municipal board
But
for integrity?
whatever may be, one thing, Mr. Datta, tell me, without issuance of any notification, can you do that?
My lord, actually what happened? That we have made an estimate, the collection of revenue and my lord, the expenditure. Now there is a much shortfall. Now unless, my lord, the revenue.
Yeah, you do. You can okay, you want to have economy. You may have it not 120, from 125, you ask 1,250 also. But if you have to do it, don't you have to issue a notification? As you are earlier, it is the board who has to do it. Now, if it is to be done, it will be on behalf of the board, the executive officer can do it, subject to the approval. Now, the approval is there, but don't you have to issue a notification for that?
Lord, what I made mistake, you know, should
Ah.
be sometime so that we can come up with a counter by making the comprehensive.
Yes, Mr.
Right.
Chakraborty,
Section 68.
68.
Yes, section 68 of the Assam.
Taxes, subject to the provisions of the rule made by the board may from time to time at a meeting conveying the in the limits municipal with the following taxes.
The procedure is very clear. There has to be a meeting and there has to be a prior notice.
Where is that? Who is the procedure?
That's section 68, the very clause, subsection 1.
Hmm.
That itself stipulates that from time
Subject to
to
the
time. at a
provisions
meet-
of this act and the rule made therein under, the board may from time to time at a meeting convene. Now, understood? Here, one has to take note of that the action is being taken by the executive officer as the board has been superseded. So the question of a meeting may not arise,
Thereafter, my lord,
Yeah.
of which due notice shall have been given.
shall have been given,
The notice is also a mandatory.
conveyed
requirement.
expressly for the purpose of which, no. Due notice has to be given, has to be read with holding of the meeting. Imposed within the limits of the following year. This is okay. But my therefore question is, the board may from at a meeting convene and in accordance with the scale of Iman, an issue, respective, nothing is necessary. But can the board or even the executive officer do anything? He has the approval, but without issuance of a notification. Merely, how can it be done?
Let me get the instruction. I'll counter also. to the fact.
Because otherwise, this aspect is, Mr. D. Chakraborty, one thing this court is finding a problem where the meeting has to be read with due notice for that meeting.
The meeting is for the purpose of enhancement of access
Understood.
talks.
But the fact that when it is being superseded, then the executive officer need not hold the meeting, but he had to take the approval of the director. Now that has been done.
Then in that case also, whether there can be no notification.
That is the
That
issue.
is the.
Without the notification, can they do it? That's your case also.
Page 31, if you look.
It's okay.
And election part also, I'm not following. for
So
the
we are
time.
not going into 68.
But
We are not going into 68. Your simple case is that you have unilaterally or without taking into consideration the various aspects have charged an exorbitant rate of tax without taking into account what is the requirement. And that too without issuance of a notification, which has to be brought to the people of the public.
And one more aspect, that too, despite the pathetic services that you are providing to the people and for which there is a commotion, there is an agitation, things are being highlighted. That is also one bitter truth, which I'm sure my esteemed colleague will agree. Your lordship will
So
see.
you want to bring
No,
the
that-
aspect of quid pro quo,
But it could for the time.
No, because these are fees. These are taxes. Taxes, there is no quid pro quo.
Exchange of, in exchange some services, my lord, that is, my lord,
These will be compensatory taxes.
that is,
Compensatory taxes, the concept of quid pro quo is not that.
but then your lordship will see who are the petitioners. Some advocate, some businessman, some retired government employee, and they want to, possibly they have some agenda. Because the other people, those who are paying the taxes, they haven't come. Like license fee.
Are you
has-
saying that the advocates, they don't pay tax?
That. My lord, they are representing, they are as if they are showing that they are representing the people of the picture. No, we have come in individual grievance, my lord. We have not come in PI.
I have, but Mr. Datta, this court is a bit lenient on this aspect as regards the locus.
My lord,
Any person may be affected.
yes, yes.
So one person can come, he has got a host.
No, that's true, but agenda, your lordship.
Because the
will find.
host had to, he had to, these people have to group together in order to take the best services from Mr. D. Chakravarti. He may not otherwise, one person may not have been able to afford it. It must have been the reason.
That area, my learned friend knows, that's the top class litigant.
That must be the reason why.
I am
So
humbled
for
by.
that one need not point out the locus on the case of the book. Yeah, issue notice making it returnable on 8/11/2024. Mr. S. Dr. Adalini Senior Counsel, Miss, what's your name? So and so. Appears on behalf of,
This one was 6.
appears on behalf of, respondent number 6. S. Dr. Nilekiti. So and so appears on behalf of the respondent number 6 and accepts notice. Full stop. As regards the respondent numbers 1, 2, 3. Now, how can you appear for housing and urban? Housing and urban, I think P. Nayak appears. You appear. Okay, you appear. 1, 2, 3, and 5. Is being represented by Miss M. Borman. Full stop. Where is Rakesh Dubey is there? Who appears for the State Election Commission?
Rakesh Dubey, okay.
R. Dubey. Have you seen him around in the? Full stop. For the present, this court is not inclined to issue notice upon the respondent number 4. Full stop. Taking into account that the respondent numbers 1, 2, 3, 5, and 6 are duly represented, extra copies of the petition will be served upon them during the course of the day. The petitioners herein, who are 15 in number, are residents of the Silchar town. Town? Silchar. First, the petitioners have alleged that the respondent number 6, it is the case of the petitioners that the Silchar Municipal Board have been dissolved and all powers and duties under the Assam Municipal Act 1956, which was required to be exercised and performed by the board, is being presently exercised and performed by the respondent number 6. It is the further case of the petitioners that the respondent number 6 have, without taking into account the ground reality, have arbitrarily enhanced the rates in an exorbitant manner. It is the further case of the petitioners that the said act on the part of the respondent number 6 is also could be learned only through newspapers, and there is no specific notification issued as regards enhancement of the rates. Mr. D. Chakraborty, the learned counsel appearing on behalf of the petitioner, submits that in addition to the challenge to the exorbitant raise to the taxes, the petitioners have also challenged the continuation of the respondent number 6 and functioning as the functioning on behalf of the Silchar Municipal Board. And that too without any elections without constituting a board within the time frame. He therefore submits that the petitioners herein have also raised issues pertaining to non-holding of the elections of the Silchar Municipal Board. Mr. S. Dutta, the learned senior counsel, appearing on behalf of the respondent number 6, submitted that after the enactment of the Assam Municipal Corporation Act 2022 and the issuance of a notification dated 12/8/2022, isn't that? 2022. The area falling within the Silchar Municipal Board would come within the ambit of the Silchar Municipal Corporation. He further submits that there is a move to hold the elections as early as possible, which earlier could not be done in view of certain interim orders passed in certain proceedings. The learned counsel, senior counsel, therefore submitted that the elections further submitted as to whether any notifications have been issued pursuant to further submitted that after preparation of the budget for the Silchar Municipal Board by the respondent number 6, the same was duly placed before the Director of Municipal Administration and there was an approval. He further submitted that in the said budget, as per his instructions, the raise in respect to the taxes have been also mentioned. The learned senior, adding further, the learned senior counsel also submitted that in the meantime, he submitted. The learned senior counsel therefore submitted that as to whether the raise in the taxes is preceded with a notification is a question which he would like to, it would be a fact which he would like to ascertain on appropriate instructions. Taking into account the above submissions, this court directs the respondent authority, more particularly the respondent number 6, to bring on record its stand by filing the affidavit on or before 4th of November 2024. The petitioner thereupon shall be at liberty file a reply.
Can anything be done for page 31?
For what?
Anything in regard to, my lord, the present imposition? If I leave it up to your lordship.
I have a prayer at
It is further observed that in the circumstance, there is no notification issued. Prior to enhancement of the issue for enhancement of the rates of taxes. Disco. No, anyway, on the next day, Mr. D. Chakraborty further submits that on the next day, this court would further consider as to whether an interim order can be passed on the facts. What is this?
My appeal was dismissed on the point of my lord time barred, my lord, but my appeal was within time, my lord.
What?
But my appeal was within time, my lord. What you will see, my lord, the order was passed on 10/4/24, my lord, at page 67.
What?
The my appeal was dismissed on the ground that I have not preferred any delay continuance in application, my lord.
Order in appeal.
Yes, the
Why it was dismissed?
operating part is at page 113, my last page, my lord.
Then for to had been and has been claimed by the appellant to have been communicated accordingly, going by the above. Near the 2 months in 16,000. Where the appeal was filed on 15/6. The appellant did not file any petition for condemnation of the responsible.
My lord, 16 was Sunday, 16th was Sunday, my lord, and 17 was holiday on account of Idul Juha, my lord. Therefore, the due date of filing of appeal was 18 June. That have accordingly I have filed on 18 June. Therefore, the appeal was within time, my lord. The appeal authority not
You filed the appeal how?
on 18 June.
How? E-filing.
Only, my lord. In service tax matter, there is no e-filing, my lord.
Then?
Within
It was
time,
filed within time.
yes, my lord, but they
And apart from that, why this is to be dismissed? If we see that judgment of Justice Indra Banerjee, I used to rely on paragraph 61. What was the name of the judgment?
says not, I think.
Huh?
Says not. Yes,
Yes, says not.
Says
Yes,
not.
failing. There it says that where is the question of filing under here?
Without,
Uh,
without any application, it can be condoned, my lord.
no, but on the facts.
Appeal is within time, my lord. This may I appeal is within time, my lord.
Where is the calendar?
This day now, High Court also it was closed on 17, my lord.
Oh, yeah. We have it. 17,
16 was
17
Sunday.
is, 17 is closed.
16 was
Idul
Sunday.
Zoha. And 16 is,
Sunday.
did Idul Zoha happen out there?
Confirmed with my lord, it was closed, my lord.
So we allow this petition. This type of matters. What do you say?
Orally also they have not prayed for condemnation of claims.
No, not necessary, na? Because it was closed. We allow it. Heard Mr. R.S. Mishra, the learned counsel, appearing on behalf of the petitioner. Mr. S.C. Kayal appears on behalf of the respondent number 2, 3, and 4, and Mr. S.K. Medi appears on behalf of the respondent number 1. The petitioner herein has approached this court, challenging the order dated 11/9/2024, passed by the Commissioner Bracket Appeals, whereby the appeal filed by the petitioner was rejected on being barred by the time prescribed. It is seen from the reports as well as the impugned order that the order in original was passed on 10/4/2024 and the same was communicated on 17/4/2024 to the petitioner. In terms with subsection 3A of section 85 of the Finance Act 1994, the period for filing an appeal prescribed is 2 months. Taking into account that the petitioner was communicated on 17/4/2024, the appeal ought to have been filed on 16/6/2024. However, it is relevant to take note of that on 16/6/2024, however, it is relevant to take note of that 16th and 17th of June 2024 were holidays on account of being a Sunday as well as Eid Zuha. And as such, the petitioner filed on 18/6/2024. This aspect, however, was not taken into consideration by the Commissioner Appeals in passing the order, impugned order, and merely on the fact that there was no application for condonation of delay, the said application, the said appeal was dismissed. In the opinion of this court, when the last day falls on a holiday, then it is a well-settled principle of law that when the last day is a holiday, the next day is required to be counted for the purpose of computation of the period prescribed. In the instant case, 16th and 17th of June 2024 being holiday, the last day for filing the appeal would have been on 18/6/2024. And on that day, the appeal was duly filed. Accordingly, in the opinion of this court, the appeal was filed within the period prescribed. Therefore, this court sets aside the order dated 11/9/2024 and directs the Commissioner Appeals, who is the respondent number 4 herein, to decide the appeal filed by the petitioner on merits. The appeal, the records of the appeal number 325/GHY bracket A, capital A, COM/ST/GHY/2024 are restored to the file of the Commissioner Appeals. Yeah,
Petitioners were addicted.
addicted.
Yes, Mr.
When?
On Milord, 12/8/2024, without Milord following the due process of law
Where? Where from?
from their land possessing.
Where?
That test to Milord, that test to.
Huh?
Who's was supporting?
Now, what can this court do?
Yeah, there was an injunction order as well, Milord. There was an injunction order as well, Milord. From the landed trial court, civil court, Uchi court. And in spite of that, they have addicted.
Then file
Yes,
order
I have-
39-2A.
I have already filed. Milord.
And
After eviction, we went there with the deputy commissioner, but deputy commissioner threw out, because he said that because of an order passed by this honorable court, he has evicted us.
this court,
Yes, Milord, but that was not the fact, Milord. Only this court has said to consider the things after taking report from the concerned CEO.
what did I could do? What mistake have I committed?
This court means, Milord, by another honorable judge.
What did he do? Ah, the entire exercise be completed here. What is this?
Milord.
Grievance of the petitioner is that he was settled with Bolshoi weekly market from 2000 Iman and Iman. Is that the case?
That is their case, Milord. one, the ratio of the market has come before the.
Upon such report may be received, the ordinance shall pass order if the landowners are found to be under illegal encroachment and the deputy commissioner will reinstate. And this order is passed ex parte.
Yes. Expert. But this order never says that go and without following due process of law evict them. This order never says that. But now Deputy Commissioner is saying that because of this order, he has to evict us.
And what happened to order 39 rule 2A?
That has been notice has already been issued.
Then why you are approaching how many forums? Then you do one thing, file another one out there in Supreme Court.
Because they are
No,
doing
there we
their-
go.
doing their work, they are earning, because they are.
Very well,
I guess
but.
Article
once you have
1921 is
already
why-
under order 39 rule 2A.
Yes, because.
Why did you this go? You got an injunction under from whom against whom?
Against Deputy Commissioner. They would,
Injunction was against the deputy commissioner.
yes,
So why should this court do it? Why are, Mr. Sahu, why are you not filing a contempt?
that has been filed here. That, under 39 rule 2A has been filed here.
That is for compliance. You can very well file a order. In my opinion, what you need is to move an order 21 rule 35 or what you may be, because for effect, giving effect or passing appropriate order. But why you are not filing a contempt here? It will come under 15 to a subordinate court order. This court can very well take it up. But would it be permissible? On one hand, you are approaching 39 2A. And here also,
But here I'm. So let's the Deputy Commissioner to consider whether this order itself says that evict without any following due process of law. That very limited method, because those proceedings will take time. And if the.
that's
Deputy
like
Commissioner-
this court also would take time.
The Deputy Commissioner at least has to consider that fact. Because of their livelihood, question of livelihood is there, method.
And who are 5 and 6?
5 and 6, that Gao Buddha Milot, and 6 is the petitioner of that earlier writ petition. Who has-
Why you are making him a party?
Because he did not disclose anything, because, because of this, because he filed this writ petition. And out of this writ petition, we have been Milot rejected, evicted Milot.
No. Being a last day, I'll issue notice. Notice making it returnable on 11th of November 2024. Ms. P.R. Mohanto appears on behalf of the respondent number 1. Ms. M. Borman appears for the respondent number 2, 3, and 4. As the respondent numbers 1 to 4 are duly represented, extra copies of the petition be served upon them during the course of the day. As regards the respondent number 5 and 6, the petitioner is directed to take steps by way of registered post as well as usual during the course of the day. You need an urgent disposal,
Urgent.
Dusty?
Yep.
Dusty? Petitioner is further given the liberty to take steps on the respondent number 5 and 6 by way of Dusty routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioners herein is that the petitioner were carrying on their business in a plot of land where?
Sir.
Plot of land is where?
Bosqua Sapori village.
There will be a dag number, patta number.
Yes, Milot, I will give you. Dark number Milot 380.
A patta number.
No, Pata is not there, Milot, because it is government land. Government land.
Of dag number 380
380 situated at village Bosqua Sapori.
at village so and so.
Moja
in the
Mahabhai,
district Moza,
Mahabhairam.
in the district of Hunitpur, Assam. Initially, there was certain steps taken under Rule 18 of the settlement rules framed under the Assam Land and Revenue Regulations 1886 for eviction of the petitioners. The same aspect was put to challenge by filing a writ petition. In being WPC number 2741 oblique 2022. It is further seen that prior thereto, the petitioner have also filed a suit being titled suit number 70 oblique 2015 against the official respondents herein, and more particularly the district commissioner, Hunitpur. And there was a restraint order so passed in Mize case number 139 of 2015. It is the further case of the petitioners that by an order dated 13/6/2022, the writ petition, who filed that petition?
Below that respondent number 6, multi ratio.
No, who were issued section 18 notice?
That DC,
To whom?
to ask
Then who filed the writ petition?
that lessee of the market.
That is respond me. You did not file.
No, we didn't.
Section, and for that you filed the suit
Yes,
and you got a stay.
we got a stay. Yes.
No.
Otherwise, the deputy commissioner will be directed to.
How can you maintain a section 18? A rule 18 notice before a civil court? Tell me. How can you maintain?
Yes, my lord. Because, my lord,
Because what? No, because business out there. There's complete bar under 154 and 154A.
my lord, because that declaration is required, because I am claiming by virtue of adverse forest. Because under section 18, I have to show my right. That right is adverse forest, and that right,
An adverse possession is permissible
yes, of course, my lord.
against the state.
State, 30 years, there, my lord.
You can file a suit.
Yes, of course, my lord, because the declaration is required.
But what do you say about the judgment of Justice Arun Mishra? Specifically say that there is no adverse possession against the state. You can't file against the state. You may take a plea, but you can't take up, you may have a defense. Otherwise, you see in that judgment, I think, what is that? Rajendra Gaur, Rajendra Prasad Gerwal, the judgment, where the issue was as to whether adverse possession would be sealed or sold. That the judgment categorically mentioned that adverse possession can both be a sealed and a sold. But however, the same shall not apply as regards the state. It is the case of the petitioner. ऊपर के निकले ना ये rule 18 और क्या लेकिन ही नहीं बात. It is the verdict, it is the case of the petitioner that the petitioners were issued notices under Rule 18 of the settlement rules framed under the Assam Land and Revenue Regulations 1886 by the district commissioner, Hunitpur, thereby to summarily evict the petitioners from the government land. The petitioners approached, filed a suit being title suit number 70/2015 before the court of the Munsif number 1, Tejpur, seeking declaration and certain consequential reliefs. In the said suit, an injunction application was filed, being Mize case number 139/2015, wherein an injunction order was obtained not to evict the petitioner. Be that as it may, while the said suit was pending and the injunction operating, the petitioners herein were evicted on when?
On 12/8/24.
12/8/2024 by the district commissioner, by the office of the district commissioner, Punitpur. On inquiry being made, the petitioner could come to learn that the respondent number 6 had filed a writ petition before this court, which was registered and numbered as WPC number 2741/2022, wherein this court, by an order dated 13/6/2022, directed the respondent number 2, the district commissioner, to pass a speaking order under representation, so submitted by the petitioner therein. First, the petitioner could further come to learn from inquiries made in the office of the deputy commissioner, district commissioner, Punitpur, that it is on account of the order being passed on 13/6/2022 in WPC number 2741/2022, the petitioners were evicted. The learned counsel appearing on behalf of the petitioner submits that the petitioners perusal of the order dated 13/6/2022 passed in WPC number 2741/2022 could not show in any manner that there was any direction passed to evict the petitioners herein. Under such circumstances, during the pendency of an injunction order, and when there was no specific direction being passed by this court, the action on the part of the district commissioner to evict the petitioner was an illegal and arbitrary action, and as such, the petitioners have approached this court. The respondents shall file their affidavit, bring on record the stand by filing the affidavit on or before the next stage.
Pendency of this petition shall not be barred for the deputy commissioner to consider our representation. For responding.
Should I close the writ petition on saying that you want to withdraw? Come up with all these things.
Railway petitioner since 2006 and retired in December 2023. Thereafter, he was not asked to vacate the ballot by any notice. Suddenly, this notice has been issued. So, 1 month time, as you lordship will have granted, my lord.
Now, for whom are you asking? Whose examination? Bluebells.
My lord. For normal, my lord, alternative accommodation, my lord. Alternative,
You know right out. Let them take action as per the provisions of law. You get that.
no, we have to, because he has already retired in December. Thereafter, no, my lord, notice from the authority to vacate. They are staying, my lord.
Are you aware of the fact that you will have to pay this rental amount?
That was not also communicated to.
You have to pay the rental amount. This will be deducted from your pension and all. This is a case of overstay. Isn't it? They were in service in those cases. You are not in service. They're absolutely illegal.
But the authority, my lord, they never also issued any kind of notice to.
They will issue notice now. Let them issue
After
notice.
retirement, he has to vacate the
They have, my lord, 30 days time as the lordship, my lord, consider on humanitarian ground, so that, my lord,
No. This is issued by the competent authority. Don't you think that it is the estate officer who has to do it? The estate officer has to do it under the Public Premises Act.
superintendent of railway police.
Huh? He's not the estate officer. How do you evict somebody? Just for example, here, to avoid further eviction procedure. This eviction procedure is mentioned out there to the effect that they will follow a procedure. Page 14. What is the procedure? The procedure is under the Public Premises Act. Isn't it?
In 7 days, they have to direct it to vacate the quarter.
Right? If they don't do, how do you vacate them? Public Premises Act, there's no other way. So Public Premises Act, you have to follow this. We dismiss his petition and say that you are going to follow the Public Premises Act. Then also you get time. But this is not the case. Your earlier cases are different. These people are working. In fact, I gave you that liberty. I even didn't put your 30-10.
how they have, my lord, disconnected the electricity,
In whose case?
this case.
Very well. Therefore. But if you say that you vacate by 30-10 on that undertaking, I will allow.
Not that, that would be
This is an undertaking being given.
not
Here, there is no requirement of following any procedure. In the earlier case, shall take due steps for eviction as per law.
As per law.
That is not going to happen here. You are to vacate on 30-10-2024. Otherwise, it would amount to violation of an undertaking being given before this court for which consequences will follow. Heard Mr. R. Ali, the learned counsel appearing on behalf of the petitioner, and Miss S. Gurua, learned counsel appearing on behalf of the respondent number
2 and 3. So 1,
1 and 2.
1.
1 and 2. The petitioner has assailed the notice dated 7-9-2024, whereby the petitioner have been asked to vacate within 7 days to avoid further eviction procedure. From a perusal of the materials on record, it reveals that the petitioner earlier was employed as a railway servant in the railway police. And during his course of employment, the petitioner was allotted a quarter bearing railway quarter number DS/10/C, capital C. Postal. On 31/12/2023, the petitioner retired after completing after at, after complete at the after completing 60 years in after completing 60 years postal. Thereupon, the petitioner continued to remain in the same quarter, although the petitioner could not have continued beyond a particular specific period. It is under such circumstances the eviction notice enclosed at Annexure 3 to the petition was issued. Mr. R. Ali, the learned counsel appearing on behalf of the petitioner, submitted that the petitioner would vacate the quarter on or before 31/10/2024. And as such, some further time may be given so that the petitioner would arrange for alternative accommodation. Postal. Ms. Esburger, the learned counsel appearing on behalf of the railway administration, submitted that the petitioner had no right to remain in possession of the quarter in question after he had already superannuated as far back as on 31/12/2023. She further submitted that continuing to reside in the quarter had a resultant effect on depriving those persons in employment of the railways who are entitled to the quarter. This court, upon hearing the learned counsels appearing on behalf of the petitioner, is of the opinion that the eviction notice so issued to the petitioner, impugn eviction notice so issued to the petitioner dated 7/9/2024, calls for no interference. Be that as it may, taking into account that the petitioner had given an undertaking before this court that he would vacate on or before 31/10/2024. This court, on humanitarian grounds, and taking into account that the petitioner would be in great difficulty if immediately evicted, permits the petitioner to reside at the quarter till 31/10/2024. It is, however, made very clear that if the petitioner fails to vacate the quarter on or before 31/10/2024, as undertaken before this court, it shall amount to a contempt. It shall amount to a contempt for which consequences shall follow. The railway authorities are directed to not to disturb the possession of the petitioner till 31/10/2024. And if the petitioner fails to vacate, appropriate steps be taken to obtain uh, take over the possession of the water.
And in other methods, the date is fixed 30 days. Here it is.
One day is this way and then.
But only when the electricity may kindly be restored. They may be asked to restore the electricity and functioned into.
You do whatever you like.
Cannot.
You are not entitled to anything. The last day of the court, I am giving you this. Otherwise, you are not entitled. I don't have sympathy. Sympathy is out of. There I am become more sympathetic. Who matters? Yes. Your matter and Mr. Sahu's matter. Yes,
In this case, all the petitioners were evicted.
evicted.
Evicted on 27/9. They were evicted.
Then what do you want to do?
Then, my lord, I may be permitted to submit our representation before the commissioner to make a claim. And further, my lord, I have no alternative place just now to go. And the authority allow me to reside there under Tombo, my lord, under erecting Tombo.
Huh?
Under erecting Tombo, they are allowed to reside as temporarily. So, my lord, now they are going to you immediately go. But till now, we are not making alternative arrangements. So I will allow to submit our representation along with all documents. And some time may kindly be given to take alternative arrangement
For what?
for residents.
Huh?
For to reside in another place, other place.
Where?
They are searching the place.
Who?
The petitioners.
Now where are you residing?
Where authorities temporarily allow us to,
They will give you. What should I say?
then will I will maybe permitted to submit representation.
I will withdraw the petition. You have already been evicted. You submit, but the fact remains, you have no right.
Right. I fairly submit, but we have no right. Just that observation may be kindly given. I will fight on 14. I will another case. Your lordship fixed the 14. I allow us to submit representation on 14. I'll let the authority consider if there is.
That is different. Madam.
They are not evicted. They are
Then submit. He is going to withdraw the petition. He is withdrawing the petition with the liberty to submit there before the authority. I will pass the order that if he submits, they will duly consider as per law. That's it. That is the relief you are asking for.
but another relief or 2 or 3 months time may
Where?
that observation
Where?
on as they make an alternative temporary arrangement.
They will know, they will.
That
Because
will-
if you make that submission, I reject it. Then the problem will be they will throw you out tomorrow from
Well,
there else.
well.
Mr. J. Ahmed, the learned counsel appearing on behalf of the petitioner, submits that the petitioners were residing in various plots of land covered by dark number 638, 551, 637, oblique 354, 653, 584, 583, 643, 600, 155, 82, 224, and 224 in patta numbers 13, 56, 109, 119, 209, 98, 10 at village Kochutoli, PO and PS, Hunapur in the district of Kamrup Metro, Assam. However, the district administration have evicted the petitioners from their possession and also had demolished their
Houses.
houses on
27/9/2024.
on 27/9/2024.
Without having any notice or.
That too, without serving any notice.
Notice was sent, my
Why, no.
notice was sent, my
Without serving any respective notice. Full stop. Under such circumstances, the petitioners have therefore approached the court seeking rehabilitation, seeking directions for rehabilitation of the petitioners, as well as also to I think rehabilitation. Rehab- And to allow the petitioners to stay in their respective plots of land on humanitarian grounds. First,
Still this without.
issue notice, no, I'm not disposing it. Issue notice because this will otherwise have, let's wait for what the Supreme Court has to say in
Yes,
that judgment. Huh? Those cases are different. Issue notice making it returnable on 13th of November 2024. Ms. P.R. Mohanto appears on behalf of the respondent number 1. Ms. M. Bormon appears for the respondent number 2, 3, 4, and 5. As the said respondents are duly represented, extra copies of the petition be served upon them during the course of the day. On or before the returnable date, the respondents are directed to bring on record their stand by filing an affidavit. In addition to that, the respondents shall also indicate as to where these petitioners can be rehabilitated, taking into account that the petitioners have been already dispossessed from the lands which they were under their occupation. In the meantime, I don't think you go for a representation.
Hello.
Let's see what happens here.
7.
Yes, Mr. B. N. Gogoi.
Lordship, here in this case, I have been affected the annex of 15. Strike off from under provision of 116 of Assam Land and Evidence without any procedure of law. And I am your page 70, Your Lordship. I am the ancestral inherited property, Your Lordship. All the things have been narrated in the last line and the invoke of the 116 of Assam Land and Evidence.
Why you're not filing an appeal?
Lordship,
Go and file appeal before the Board of Revenue.
Your Lordship, they have already been proceeding the cases. So,
What proceeding? Your name have been only removed from the Patadar.
so they have removed, they have already proceeding the vacant land, but to oil.
For
Is-
vacant land.
The land which have been stricken from me, Your Lordship, the government has given to the stakeholder SIDC. And the SIDC has given the to some oil.
No, they can't do that.
That is not happening, Your Lordship. That's why
This is, the land is in your possession.
the land is in my possession, but they have bounded by that oil now. The land has been, 4 corners of my Dakota land has been constructed by oil. With that connivance of SIDC, Your Lordship.
And how did you get the land? The rights over the land?
I have repeatedly have been given a written objection. They have
How did you get the rights over the land?
rights of the land is in my strike of, it is my own land, Your Lordship.
Sale deed,
No, it's ancestral property.
ancestral property. Yes.
The old Guwahati, old citizens people here. These people are old citizens people and the ex-MLA.
Yes, Mr. Borbuzari. Your deputy commissioners or whoever it is, are these people not aware of what is rule 106, section 116? 116 has a connection with section 51. Whereby, if a person is found not to be in possession of the land, his mutation you can cut. His mutation can be taken away.
Got it.
But can you divest his rights? His title over from the land? No.
Revenue authority cannot enter into.
Now, how is it this being done?
Annex 15, page 7.
My lord.
You can't make it a government land. It will have serious consequences. What is this?
This is the observation by the honorable, here this book, Your Lordship. In paragraph,
Hope I know the law.
this,
This order says, well, if I may read it, my lord. Whereas land measuring 5 figure 2 lesser allotted lease by ASIDC to erstwhile Messrs. Escon covered under old dark number so-and-so village so-and-so, which as per Government of Assam decision subsequently has been allotted to Oil India Limited by ASIDC, is part of land covered by new dark number so-and-so village so-and-so, and are belonging to the industrial estate ASIDC as per records present with the land records branch of this establishment. And whereas land measuring 30 bigha acquired by Government of Assam for allotment to industrial estate as per government notification dated 1958, where all dark numbers so and so, with a total area of 30 bigha 1.7.9 lakhs of land. Whereas as per Circle Officer Guwahati Revenue Circle report, a land measuring 1 bigha 1.7 covered by dark number so and so is under possession of oil is a patta land in the name of Rana Goswami. So and so, so and so. Moreover, as per records of land records branch of this establishment, is a part of land evolved from the land measuring so and so after resettlement period of 1986-09 as per draft Jamapandi belonged to Kumudeswar Goswami, Bimala Devi. The same land had evolved from dark number 330 after resettlement period. The dark number so and so amounting to so and so was in the name of Kumudeswar Goswami, son of Maheshwar during the resettlement period as per draft Jamapandi. Whereas all the petitions and objections in the written statement along with revenue received paid recently as on 13/6/24 were submitted by the legal heirs of late Rana Goswami in connection with the land covered under tag number 121017 of Kepipota 116 of village Bamune Moidam only after commencement of this case and thereby issue of hearing notices to the Pattadar. In view of the above and power conferred upon the undersigned, as per Rule 116 of ALLR, the names of the recorded Pattadar, namely Rana Goswami of so-and-so under his stricken off and the tag number 1217 to be made government land. Hence, the Circle Officer Guwahati Revenue Circle is directed to correct the land records accordingly. If he is a Pattadar, that might not, of course, consequences will follow. 116.
116 has the correlation with 51. You see what happens, you see, if you understand when you do a mutation or the revenue records is on the basis where it's categorically says that you have to have title and possession.
Title and position regulation 40.
So that is required.
Yes.
Now what happens, 116 comes into play when you don't have the possession
Don't
and
have-
say you have your name, but your possession is not longer. Then the deputy commissioner is being given the power to strike out
Yes.
the name from the mutation and
Yes.
it affects the revenue records.
Yes.
but you can't make it government.
Yes, 116, for a moment, madam, if I may read it, Lordship is correct. Power of Deputy Commissioner to order the name of a proprietor of etc. be struck out of register. Whenever it comes to the notice of the Deputy Commissioner that any person whose name is recorded in the general register as proprietor, settlement holder, or manager of an estate is no longer in possession of any such interest in the estate, the Deputy Commissioner may order the name of such person be struck out from the register, provided that the Deputy Commissioner shall not strike out the name of any recorded pattadar or landholder or manager of a proprietor without giving him due notice and hearing any objections he may prefer against his name being struck out. Now here my lord, opportunity of hearing was given.
No, whatever may be. How can you make it government land? You can't make a land, a person's property by way of this provision. You can't make it a government land.
So, but if, no, assuming if upon exercise of power, so and so's name is struck off, so he goes out.
This is something with regard to notice. You see, how do you enter your name in the revenue records? Either under 50, by filing an application, or under 53A, bringing in that during the resettlement operation, look here, this is the transfer which has happened and this is the possession I am happening.
Yes,
And on the basis of that, it is done. Now, if your possession is not there, you don't have a power under 50 for removing your name. This is the power which is being given for striking out.
no. So why
You
I,
lose your possession.
yes, no, I lose my possession. Now my
But
lord,
you can't make the government.
no, I can understand. Now if there are other pattadars in that patta, because my lord, 116 will only be focused only to the person concerned if he is not in possession. There may be a patta where my lord, we commonly term it as Mali patta. There are several pattadars. One of such pattadars is found not to be in possession. Applying the provision of 1160, it may be my lord stuck off. It may be stuck off. Then other pattadars will remain. I cannot change the nature and character of that patta by applying 116. Because
No, you cannot. He has no power to remove that patta. You see, that is not, you can't make that way. The power is from striking out from the register. See, therefore, here the power has been given for striking out from the register. And you see, 50 shows for insertion of the name in the register.
50 is also referring to regulation. That's what my lord.
This is for insertion in a, and on the basis of the register, these rights are made. So the patta, you can't touch it. Patta remains because the title is yours.
Yes.
You may strike out from the Jamabandi. You may strike out from the Chita, but my patta remains it. Therefore, it is the basic idea that revenue authorities cannot create or destroy or give evidence that this is the ownership.
Yes. No,
That is the
that-
basic
that-
idea,
that-
philosophy.
That law is settled, yes.
That is the idea. So therefore, they can't create. They can't destroy. If they can't create or destroy, then how do they take away the patta and make it a government?
Therefore, so 116 only, my lord, spells about exercise of power. Nonetheless, it is silent to the consequences after exercising the power. What has
No, no, no. I hope that your district commissioner knows what is the law. The law is well settled, long time back.
Otherwise, then, my lord,
Anyway, you
if it
say
is
this
converted,
immediately. Immediately. This is a case for forfeit,
No.
setting aside this type of orders. And wait, what is the reason given, Mr. You hear it, it's okay, but what is the reason given?
then it is allotted to some government.
What is the reason given? In view of the above, and the power conferred upon it, the names of so and so as-
The names of recorded pattadar is stricken off. That extent I can understand. And tar number 1217 to be made government and hence the circle officer is directed.
Reason is somewhere, I think he must have kept it in his books.
Lords,
The affidavit is
Amount is
filed and
there,
we will-
Obviously, I'm giving you, because
For-
tomorrow you may say that the affidavit has not been there. And as such, no affidavit opportunity
Chairman,
was
what
given.
text might we need to-
Issue notice making it returnable. I'll give you very proper time on 4th of December 2024. No, we make it 11th of December.
You will be protected in the interim laws.
I'm
It's protected.
staying.
So therefore,
You do better other things. 4th of December 2000.
let it be, my lord, 4 weeks, my
Deputy
lord.
Commissioner knows everything, your lordship. He will be very open.
4th of December 2000.
Before 4th of December, my
No,
lord.
no.
4 weeks, my lord, I'm praying
No,
4
no,
weeks. My lord,
no,
we-
all
we-
notice we have to.
All people are there, your lordship. This is not only one case, your lordship. Other people also come. Yeah, how the conjugation have been done by the deputy
They
commissioner.
will come, my lord, I am concerned with the
You
lease
file
in my
an
hand.
IAF.
Assembly,
I am concerned with my lease in my hand, my friend can live with being other people also.
The Arbogari appears for respondent number 1 and 2. The H Sharma appears for the respondent number 3, 4. As the respondent numbers 1 to 4 are duly represented, extra copies of the petition be served upon them during the course of the day. As regards the respondent number 5 and 6, the petitioner is directed to take steps by way of registered as well as usual during the course of the day. I don't think you need to serve by the steels. The petitioner hearing, I challenged the order dated 6/9/2024, passed by the District Commissioner, Kamrup Metro. On the ground, that the power so exercised under Rule 18, Section 116 of the Assam Land and Revenue Regulations 1886 do not vest upon the District Commissioner, Kamrup Metro, to divest the petitioner from the land, from the rights conferred upon them. How many petitioners? Upon him. Divest from the petitioner the rights conferred upon the petition from the land. And as such, the impugned order dated 6/9/2024 is without jurisdiction and authority. The learned counsel, Mr. B.N. Gogoi, the learned counsel appearing on behalf of the petitioner, further submits that when a hearing is required to be given, there is also a requirement that the order should contain reasons. A perusal of the entire order dated 6/9/2024 would show that the same is bereft of any reasons. He therefore submitted that this is a case where the District Commissioner, Kamrup Metro, have exercised powers beyond his authority, and as such, required to be stayed. This court have, while dealing with the, had also heard Mr. R. Bortuzar on this aspect. And upon anxious consideration being given to the respective submissions and taking into account the provisions of Rule 116, Section 116 of the Assam Land and Revenue Regulations 1886, this court prima facie is of the opinion that the power so exercised by the District Commissioner in the impugned order is beyond his jurisdiction. Inasmuch as it is a well-settled principle of law that neither the revenue authorities can vest title, nor can extinguish title. Under such circumstances, this court states the impugn order dated 6/9/2024 till the next day.
Lordship, I want to point out one thing.
Yes.
The impugn notice is issued by the deputy commissioner. And unfortunately, no copies were served upon us.
How does
But,
it
as
be
to-
served? If Lordship permit me, if my learned
I
friend
have-
stated that I have not received, how this petition will come? I have given all the things.
No, Lordship, I can show it from the record. That is why after checking the record, I am placing as because today is the last day
It has
of
been
the
served upon whom?
ASIDC and revenue, not
No,
upon the.
state of service,
No,
everything.
Lordship. I've checked the file. That-
Anyways,
But today is the last day of the, because of that, I have not stated all these things, but the copy should be served, Lord.
No, definitely I will
I've asked him,
I undertake. you.
Mr. BN Gogoi, you are normally on this side, no? So think what will happen. You will also face similar consequences later.
It's difficult on our part, Lordship. I think we can-
Anyway, therefore, I asked Mr. Warpuzari also.
Whether exercising 116, he has exercised a colorable exercise of power. That will ultimately follow.
Not a colorable exercise. It is not a colorable exercise means safe. He has the jurisdiction, but have done it for certain wrong ends.
Lordship.
But this is not for that. He has no jurisdiction to do that. To divest the, the title.
He has exercised. First stacking up, then diversity. Which could not have been done. That's it.
I think that.
For admission item 7.
Deep lovely. Was it 4th December? 4th December.
Huh?
4th December fixing. My meta is fixing 4th December. Lordship, and deep love.
Yes, Mr. Sharma.
May please your lordship.
What is this matter about?
My lord, this acquisition of land lordships. This.
Pay fair compensation for acquisition of land covered by dark number so and so. What is the stand taken by the deputy commissioner?
This deputy commissioner has
Stated
admitted
for the record so and so be the.
Paragraph 8,
so
Lordship, page
so
18.
and so. Go there. Take the money.
lordship.
Mr. Harsha the learned counsel appearing on behalf of the petitioner submits the taking into account the stand at paragraph number 8 of the affidavit filed by the respondent number 2. The petitioners would be well advised to approach the respondent authorities for claiming the compensation which is kept, which had been lying undisbursed. Footstep. The learned counsel, however, submits that, footstep. Mr. H. Sharma, the learned counsel appearing on behalf of the district commissioner, submits that in the circumstance, the petitioners approach the respondent authorities and show the documents of title or any interest over the land in question to fall within the ambit of the ambit of person interested in respect to the acquisition. In respect to the said acquisition, the respondent, the office of the deputy commissioner, where
Kamrup Metro.
Kamrup Metro would have no objection in releasing the undisbursed amount. So taking into account the above, the instant petition therefore stands closed, thereby granting liberty to the petitioners to approach the office of the deputy commissioner to claim the undisbursed amount. However, in doing so, the petitioner shall show the basis on which the petitioner claims to the said amount. It is further observed that upon the petitioners approaching the Office of the Deputy Commissioner shall pass, shall disburse the said amount if satisfied on the basis of the documents, and if such application is rejected, the same be rejected by way of a speaking order.
Ultimate.
Then you can do whatever it is. If it is rejected, you go and file reference. Yes, what is this? None appears for a petitioner.
I want to comment earlier the learned council is sorry was the youngest council also. And he expired.
Where is the, not to carry, after carrying out eviction against the petitioner, huh? Original report of the report submitted before him by the circle officer supervisor, and after carrying out eviction against the petitioner, issue a rule. What is this case? You want eviction to be carried out?
Says lordship, earlier lordship, Mr. A. Sharif was the council lordship. He in the meantime expired lordship. Thereafter, we have been appointed, and we are unable to test out the office brief lordship. That's why
Of
office brief lordship, office file lordship. That's why I'm going for adjournment.
who was the councillor? A, sorry.
Sorry, expired. And
So ask your petitioners.
lordship, that's why I'm seeking some time lordship.
The request of the learned counsel for the petitioner matters then adjourned to be listed after vacations. But these are old matters, isn't it?
No problem.
Settlement of land, my lord. Kindly see the last order dated 31/5/2017.
You want?
Lordship, there was 23/9, Lordship, last order.
Yeah.
Here is a receipt of
You have submitted?
page 30.
Then what remains in the petition?
Page 30.
What remains in the petition?
But the petition is, my lord, I don't know what they want to, but we have filed the application for seeking, my lord, page 33, my lord.
What are you asking?
My lord, this order mechanically kept, my lord, make it absolute, my lord, till disposal of my application. Page
Which one?
33, downside receipt.
Dispose of the settlement. So you have now filed fresh application.
My lord, fresh application.
No, my lord, they did not submit any, my lord, application, my lord, as part of, my lord, their Bosundara, my lord.
No, my lord, not Vasundhara, my lord, 2016, my lord. That point of time doesn't require, lordship, can see page 33, downside receipt.
What did you say?
My lord, at that point of time, we have to file the application this format. Vasundhara come later on, my lord. This is 2016 application. Downside, my lord, there is a receipt, my lord.
Here the order of 23/9 say the petitioner may accordingly file a fresh application. Have you filed?
Application we have got.
You dismiss it. You are not interested.
Lordship,
Seems from the this court had provided an opportunity. We dismiss it. What no, no, so this is of 2022.
we will
and-
file a fresh one, my lord. Right.
And where is the eviction order?
So that notices, my lord,
Where?
well, there is a threat, my lord, from their part.
On apprehension, my lord, they filed this.
Because that point of they moved the
Oh,
drive,
eviction apprehension.
well, because they moved the drive that area, my lord. That point of time moved the drive on to that area, my lord. That's why, my lord, we were also.
No,
apprehensive.
no, there is nothing. You have, no, there is no stay order also.
My lord, there is stay order, my lord.
No order.
31/5.
31/5.
Yes.
Yes, it is provided a petitioner shall not be without following due process.
process.
So that is always there.
Yes, my lord.
Rule 18 is also due process. What order is that?
But we may allow to file fresh one, my lord. Let them continue.
You file? Mr. J. Hendig appearing on behalf of the petitioner, a respondent
okay.
submits that if the petitioner herein wants to take benefit, has to fix the petitioner's hearing wants any settlement to be granted, allotment or settlement of land to be granted in their favor. The petitioners are required to file applications in in the online portal, that is Vasundhara 3.
See, my lord, yes, from my lord, second of October, it is started. Okay. 3.0.
3.0. So it is further seen that on 23/9/2022, this court observed that the petitioner may file fresh application However, the Mr. S. Samaria appearing on behalf of the petitioner submits that no such applications have been filed as per his instructions. So, taking into account the above, this court have also taken note of that the instant writ petition was filed on an apprehension that the petitioners would be evicted without following due process. However, 7 years have passed by and no action have been taken by the respondent authorities till date. Accordingly, this court disposes of the instant petition, thereby granting liberty to the petitioners to submit fresh applications for settlement, either in the online portal, that is Vasundhara 3.0, or in the offline mode in terms with Form 125 and 126. In addition to that,
My lord, the eldest council is Manjuli Dev is out of station today, so can it be kindly be listed after the holiday if possible?
Mr. Counsel, you have been taking time every time. Every time you are asking for time. Whenever the matter reaches. Why?
My lord, before Ms. Manjuli Dev had a serious health condition for which she couldn't appear for over 1.5 years. She had a backbone issue for which she was operated. But now she has gone for medical checkup. So my lord, she has stated me that just after the vacation, she can appear at the matter.
You are suffering?
Already a suit has been filed.
For what?
Actually, sort of a boundary dispute, my lord. I am appearing for a private respondent. Suit has been filed. We are contesting the matter there. Unnecessarily, in any case.
It is seen that the petitioners, the counsel for the petitioner have been seeking time on every occasion since 2020, whenever the matter has been listed. It seems the counsel for the petitioner and today also similar prayers have been made. It seems that the petitioner is not interested in continuing with the litigation. And the reason seems to be apparent from the submission of Mr. G. Rahul, who appears for the private respondent, that there is already a civil suit filed. Accordingly, list this matter in its usual course by the registry.
12 and 13.
What are these matters?
Sir, relates to the dispute between the repetition and private response number 6 method. Here, my lord, the petitioner has constructed a building, my lord, in his house, and there is an allegation caused by the, my lord, response number 6, that he has some deviation.
You are asking, challenging a notice dated 1911.
My lord,
Where?
my lord, page, my lord, 29.
29. A hearing was conducted at the, after discussion. Following decision, there shall be a passage of 9 feet breadth to the house of Sudip Kumar Borua and shall implement the law, otherwise the office will take up. This is a decision. Then,
My lord, your lordship may kindly see, page 26, in except 5 minutes.
So there is an interim for stay, my lord. That is why, my lord, they have enjoyed the rights. After duly served notice and other related documents and on the basis
no.
of my complaint.
first of all, 1911, 2018 is a,
Impugned.
is an order, not a notice.
No.
You are mentioning it as a
Yes.
notice. Okay. Now here, there was a requirement of keeping a passage of 9 feet.
Right.
Breadth. Which you have not kept
My lord.
by enjoying an interim order.
That is not the fact, my lord. What happened? Kindly see page 26, my lord, and except 5. That is an order of the, my lord, administrator, Nagar Development Authority. But the order reflects that notice was issued to me and my lord, the respondent number 6, along with a, my lord, copy of report provided by circle officer. And that was fixed.
No, hearing which was held on 30/11/2018, where you present,
Yes,
was it decided out there? At present, Korea and the opposite party are present in a minute. Detailed discussions about the building construction is held. Statement of both the parties are taken. After discussion, following decisions are taken. There shall be a line. Jogeshwar Bora shall implement the decision. You are Jogeshwar Bora. And within 1 month and a year. Otherwise, the office will take action. So let the office take action.
my lord. Kindly see.
No, the
Mr.
office will judge as to whether this 9 feet breadth to the passage should be there or not. Let them decide. Isn't it?
They just
Oh, my-
open to sky.
Huh?
Take note of that and they will inquiry. And after hearing both the parties, they will take it.
Who?
Municipality, because people go, municipal board, because
Yeah, my lord.
development now after becoming A of the municipal act, development is. I am suffering long back, my lord. We have approached notice court in the year 2015, my lord. Prior to that, we have made complaints, my lord. And my lord.
For
again and again-
non-compliance of this.
My lord, without giving reply, my lord, they have filed another petition. I am the petitioner of.
The reply to what?
49.
The reply to what?
Make him a party, my lord.
In the
Yes,
requisition.
great petition, but they have not
But
given
my lord,
reply.
Initially, notice was not issued for me, my lord. That is reflected in.
They are always conveying the
We have
illegally.
annex, my lord.
There's a
The
clear.
notice-
And for whom are you paying? Is it not there? Is the Nagaon Development Authority is there or not?
Yes, but now,
Power has been, my lord.
it's the way of the municipal act, that after that, amendment, the power is now with municipal board.
To
Not the development.
take decision. my
Regarding
lord.
the construction, etc. Municipal board. Then I will again supply.
till then nobody may be disturbed.
Mr. Council, anyway, both of you, you are fighting for last 7 years. He's suffering from, you are fighting for the last 9 years. He's fighting for the last 7 years. As of now. If on the other hand, if this court disposes of both the petition, thereby directing the Nagaon municipal board, na, to decide on the conflicting claims of both the parties and take a decision, and they will know what is to be done.
Will we agree?
I not actually, meanwhile, there was some settlement process also, but most probably that has not been at the final.
My lord, I have asked my clients, my lord, therefore let the matter be fixed after.
Otherwise, my lord, we have no objection in remanding back to municipal.
No, because that needs to be, somebody has to enforce.
My lord, due to, by giving some observations, my lord, or regarding the amicable settlement, my lord.
That is what I am saying. Let the decision be taken by the Nagaon municipal board by hearing both the sides.
Right.
Because one has challenged, one is asking for enforcement. The question whether this court should look into it now as to whether the 90, because here there is no reason being given in the order of 1911. Here he says that after detailed discussion of the meeting is held, statements of the after discussion following decision. The decision does not contain reasons. So obviously this order is bad. So therefore the question is, it is for the best for the Nagaon municipal board to do it. But at the end of the day, if this is not taken up today, then no, this court has no problem. But you are the person who is going to suffer. You have
Then,
to,
my lord,
at
direction, my lord.
one day or the
But there
other,
is
the
already
matter will be
findings, my
disposed of, huh?
But there is a findings, my lord, that there are some deviations, my lord. And
Maybe it is,
the
therefore
road
the
is-
Nagaon municipal board can look into that. Don't you
Fine.
think that?
Fine.
What do you say? Oh, so it be
I have
after
no-
vacation. I have no problem.
Objection, my lord. in
I
the-
thought in the better interest of the parties, but as you have some reservations, list the matter after vacations. Taking into account that there is some mutual agreement, mutual negotiations going on between the petitioners of both the petitions.
14,
You want a date?
my lord,
You want a date?
after vacation.
after vacation, any form that,
The matter of the petition
after 28th,
on 13th of November.
30th.
14.
So we are in this case, respondent number 4 supposed to file fresh inquiry report, Lordship.
My lord, several times have taken
On the last order,
Who is to file?
government.
Government will file.
Yes, already they have.
No, I have asked him a question.
on the last occasion, Lordship.
Oh, yes. What has happened? Government,
Earlier they have.
because this
I did-
court have duly taken note of the electrical accident report, and it surprises to take note of that while the accident occurred on 30/6/2019, the electrical accident inspector have held that both the petitioner's husband as well as employer were partly responsible on the basis of a regulation which came into existence in 2023. So you have to therefore submit a fresh report.
Lordship.
Then?
The authority sent the same lordship, sent inquiry report, which I have already addressed with the affidavit.
Have they mentioned about the new regulations? Same. No, that means they have not understood the order.
That may be.
So should we ask them to get it translated and put it in Smith? No, I'm asking you.
Lordship,
You can ask the authorities.
Lordship, can
We
you-
have nowadays a machine. You can put it in Google Translate. It can be done.
can
If
you-
the authorities, they don't understand the simple language in which this order is made,
immediately after vacation, Lordship.
Ms. So-and-so appearing on behalf of the respondent number 4 submits that immediately after that the reports, fresh inquiry report as sought for by this court have not been furnished to her. So taking into account the above, this matter on 4th of November 2024, on which date the respondent number 4 shall ensure that the report is placed before the court. In fact, this is a case of culpable, contribute.
No, my lord. Actually, the government employee, the respondent number 10 is a permanent government employee. He engaged a victim and to repair a faulty electric transformer.
No, it's okay, but that thing I have already mentioned. The day I passed an order in that regard. You got it on contributory negligence also, they are liable. Have you got that order or not? How can I help you? With that order, it can help you out. Because the APDCL will say that we are not totally liable. As per even by the report.
But they have partly accepted the engagement of the victim. They have accepted in their reports also.
That is okay, but then also. Anyways. Yes. Contempt. Fixed on so and so. Made in application to increase so and so, so and so, so and so.
Senior is submitting a maintenance part pay, the
Huh?
matter may be taken up after vacation.
No,
After we keep.
no, that's actually, I think, directed me to bring some instructions, right?
Oh, yes,
Number
yes.
16. There is a complaint with Lakshmi, I can dispose of those.
Oh, there I passed an order.
Yes, yes.
Mr. N. Goswami appearing on behalf of the to what further steps have been taken by the circle officer in pursuance to the order. Yes.
Already completed.
Then, but there,
Need to wait.
like it. This is why last time I pointed.
No.
Come up with a, why do you want to delay these type of matters?
Something from the intense part to the it's on the side.
Already corrected Lakshmi.
You are referring to which order? I am to submit the mutation cases dated are disposed of and according the record of rights also updated. Yeah. Yeah. There was a direction to dispose of the mutation case.
It is long back.
Yeah.
Something
It has
was-
been already done. Why you are doing all these things?
Committee.
Oh, I'm putting this, and then it is, you check out the record of rights. In the record of rights, it is available in the Dhaitree.
The May, in about the May.
Then. Mr. N. Goswami, the learned counsel appearing on behalf of the learned junior government advocate.
Look.
Pursuant to the order dated 25/9/2024, had submitted that in pursuance to the directions passed by this court on 21/6/2024, isn't it? No. Pursuant to
21/6.
on 21/6/2023 in WPC number 2202/2023. The mutation cases being MET/GUW/2017-18/3884/OMUT and MET/GUW/2018-19/241/OMUT have been already disposed of and the record of rights also updated. In that regard, he has placed before this court an instruction issued by the Circle Officer, Guwahati Revenue Circle, dated 3/10/2024, along with the corrected record of rights as well as the order sheet. The same are kept on record and marked with the letter X. In that view of the matter, the order dated 21/6/2023 in WPC number 2202/2023 having already been complied with, the instant contempt proceeding stands dropped. Okay. The petitioner herein would be at liberty to take certified copy of the document. of the document marked with the letter X.
Lordship, put that registration number 2202 of 2022. Registration number 2202 of 22. Lordship, put it 23.
2202 oblique 2022 or 23.
22.
22 ये order की भूल के लिखी है और साबो है मार्टिन वाले अपनी भूल के या तो ये तो भूल के लिखी 21/6/2024 it is 21/6/2023 वो साइल over there they go numbers on the correction disposed I disposed it may not order it. Yes, let us finish up these matters. Item 17.
Matter, my lord, sanction order proposal refund has already been received, my lord.
See,
But amount has been not disbursed yet.
Yes, on third of October, my lord, that order has been,
go to the order is in.
no, my lord, that instruction copy last order is received. Revenue has sanctioned the money, my lord.
This
It
is
will be debited to the account of the petitioner.
Yogeshwar Das. You are Department for NOK of Royunur Ho, Swaraj Chandra Roy, and Bhuladas. You are Bhuladas?
Yes,
Oh, well, similar order.
yes.
No, since that day I passed an order, na, I closed it.
So it's that difference.
That order, na,
Yes,
this is
but
the same.
Similar, similar.
In the year earlier, it was Swaraj Chandra Roy.
Yes.
You remember?
Yes, Lordship.
Now here, you didn't get this document. No,
Oh,
this
that day
guy-
I have.
In that document
And
only.
So
that's
far as
Bhula Roy.
I have taken instruction from my client whether they are get or not.
No, they will get it.
Yes,
This
But
order
yet
is
not-
passed on 29.
yesterday, that sanction order has been cut for debitation, my lord. That money will be debited to his account, my lord.
You have that order number? You closed it, the content now. Didn't I do? What was the number? Name of the case?
That case.
That is of this Swaraj Chandra Roy.
Yes, but I have.
Contempt petition was the lordship, that
It will be here.
Yes.
Contempt petition is
777.
Yogeshwar Das 459. This is 459. This will be 477.
Yes.
It will order direction 477 of the 2022. Same order. And naam to be, same order. It will mark for him X.
What even your lordship, in earlier occasion, your lordship disposed of my contempt petition and revenue already disbursed the amount to the DC. And your lordship was pleased to dispose of. And after that lordship, 1 month deputy commissioner line.
Mr. Council, kindly appreciate. You have filed the contempt against whom? In that case, only Gyananda
Only
Bharati.
Gyananda. There is two.
Yeah,
This
there are
also.
two.
Yes.
So there, we are mentioning about those, na?
Yes.
So this will be paid. Itali at a line at a likhi. The so and so who appears on behalf of yeah, submits that within 14, that on last number, submits that on 3/10/2024, the amount has already been disbursed to the
Order for sanction has already been issued.
order for sanction has been issued. Amount disbursed.
That information I have to take, my lord, because it is yesterday only. So it will take 2 or 3 days time, my lord, to debit the amount, my lord. The petition is now.
Admits the instant contempt application has been filed alleging willful and deliberate violation of the order dated 5/2/2024 passed in WPC number 7027 of the 2022. Full stop. Ms. M. Borman, the learned counsel appearing on behalf of the respondent number two,
Deputy Commissioner.
submits that the amount have already been sanctioned and amount have already been sanctioned by the Revenue and Disaster Management Department. And the budgetary allocation have also been issued to the respondent number two. Full stop. She therefore submits that the said amount would be disbursed to the petitioner within 10 days from today. Full stop. Taking into account the above, in that regard, she submitted a place before this court an instruction which is kept on record and marked to the letter X. Taking into account the above, the instant contempt proceeding stands dropped. Full stop. Then. Tara na.
Again,
It's the matter of. What is this?
respondent number 23 has filed an application for impediment. I have no objections, they may be impeded. Otherwise, the service has been complete and the respondents have to file their replies. Apart from one respondent, nobody else has filed.
Well,
Yes, I am appearing on behalf of the applicants. The respondent number 23 died in 2019. The present applicants are the legal heirs of the deceased respondent number 23.
don't allow go to. You file a fresh memo party. On the basis of that, petitioner is granted to file memo party within 7 days. And now you are going to file in name for a demo. You, what's your name?
Arnab Nair.
We are appearing on behalf of the newly substituted respondent submits that we file an affidavit. This the matter again on 9th of December. The
Obliged.
affidavit we filed on the 4th of May. I can allow going. Yes, 10/20.
On the last occasion, my dear friend was asked to submit a obtaining instruction from the client and received the instruction to be.
Huh? Huh?
Hearing was
Eviction in the next day, no coercive action be taken. Without reason. Yes, what is your instruction?
the hearing was conducted, there are
Hey, Diokta,
notices were issued to the encroachers. Now they will be evicted.
order passed.
Yes, this is the order. 5. Then thereafter, my lord, there was a hearing.
Okay, so the order has been passed. Who is appearing for the Muchi Babastan? You are there. You do one thing, bring this on record by filing an affidavit. Mr. J. Talukar, firstly, the Learned Council, Senior Government Advocate, Additional Senior Government Advocate have placed before this court the instructions. It would be in the interest of justice where the said instructions are brought on record by filing an affidavit. Accordingly, list this matter again on 13th of November 2024. The instructions be placed before this court by filing an affidavit by 4th of November. First of, the petitioner thereupon will be at liberty to file reply. The private respondent would also be at liberty to file their response by 4th of November. You keep this, the interim order passed earlier shall continue till then.
Right.
Similar.
Same, na? Okay, same order. Yes,
Your Lordship, yesterday the matter was called out and we were on the point of delay in filing the compounding application. So we have filed a chart number 1, giving the calculation of the delay in our case. So if we see effectively, after the Supreme Court's exclusion period is to be considered, the delay effectively is around for 6 months only. And we have also given a compilation of case laws wherein we have quoted the High Court judgments which have delayed the condoned the delay for even as high as 20 years. Your Lordship, if you come to page 83 of our compilation,
how many cases are here?
Your Lordship, here we have quoted 5 cases which are identical to the facts of my case. So we have given a comparative chart. In fact, the last case, JAK Communication, is also where the time limit had expired during the COVID period. However, the court had excluded the COVID period time and still granted the condonation of delay. And these all pertain to the application for compounding for prosecution only under the same section. In the compilation, we have given 8 judgments of various high courts. There are many others, but in order to not burden your Lordship, we have just given 8 judgments which have comprehensively decided this issue.
Here, why there are 3 repetitions?
Your Lordship, so there were 3 financial years, an assessment year 14-15, 15-16 and 16-17. Identical case where there was default in delaying payment of TDS. Identically, we had filed compounding application against prosecution and they have rejected my compounding application on identical ground of delay.
And it is also identical when you have filed the application for compounding.
Yes, your Lordship. Even that is identical.
14/8/2023. What is the date of filing application for compounding?
It is 14/8/2023 in all the 3 years.
Now, your case is that 279(2) does not prescribe any period.
Yes,
for
your Lordship.
computation of the, as to when where the income tax account. Income tax.
Of the revenue portion, GP.
So this period as being not there, this is now being, the void out there is being supplied by some executive instruction.
Yes, your Lordship.
Now, the executive instruction is being challenged here.
Your Lordship, we have not challenged the CBDT circular in this petition, but we have taken the argument that the condonation should have been allowed in absence of any provision under the Act.
What? Whether the executive instruction would not supply the void, and wouldn't that also be a legislation?
Your Lordship, CBDT do have the power to supply any additional limitation period, but that cannot be in contravention to the provisions of the Act. It has to supplement the Act.
There is no contravention to the provisions of the Act. The provisions of the Act specifically mention that there is a power to compound. But the question is the provisions of the Act does not mention as to when it can be filed or when it cannot be filed. So this void which is there is being supplied by the CBDT circular.
Your
Now,
lord,
this circular having been there, if you don't challenge the circular, how are you maintaining your challenge?
so your lordship, we can challenge the circular in this petition itself, but there the other high courts have also read down the circular in the absence of a challenge on the directory powers of the CBDT. Even the explanation to section 279, which gives the power to CBDT, it only provides them that you can enable the procedure for compounding to be facilitated in the act.
A circular being issued by an authority, more particularly the CBDT, is binding upon the officials. It may not be binding upon the court. So if it is binding upon the official and you want this court to exercise its power of judicial review, this court, how can it say that the decision-making process was wrong?
So
Because here, under 226, we are not going to, I'm not sitting as an appellate authority. I'm only sitting as to see as to whether the decision-making process is wrong.
yes, your lordship. Your lordship, if we can come to the judgment in case of Ahmed Kabir,
No
Madras.
Judgment, I'm not. Judgment has nothing to do. First of all, without a challenge to the CBDT. Yes, once you challenge it, this court can very well read it to that effect that, yes, they have mentioned it to be 30 months or 36 months out there. But in exceptional circumstances, it can be done. There might be, if good reasons are given, there can be then also be taken note of, and this aspect having not been taken into consideration, this court can exercise our power under Article 226. But without a challenge to the CBDT circular, otherwise they are right.
Your lordship, we can amend the writ petition to challenge the circular also. But the argument as far as the CBDT circular and its applicability has been taken in the writ petition.
You have taken everything, but without a challenge.
So,
But
your lordship, we will
This court
amend the
as well-
prayer.
You see, this court cannot this court cannot also say that the CBDT circular is directory. The directory aspect only means that you don't need substantive compliance. But then also you have to give a power to the authority. The authority is bound by the circular. So you
Yes,
have to
your
read
lordship.
down the circular. But how do I read down the circular unless there's a challenge to the circular?
I absolutely agree with your lordship. We can amend our prayer clause in order to challenge the circular on that ground of reading down the circular to the extent it prescribes a time limit for compounding of
There are
application.
two ways, therefore, left. Either you have to withdraw the petition, then refile it by making that correction, or file an amendment application which shall be allowed and thereupon to file the same bunch of papers again. Now, which option would you like to take?
Your lordship, if for the sake, since the petition is already filed, I think it will be convenient if we can amend the present petition
So
itself.
you will file an IA. After filing an IA, this matter will come up. This court will then pass an order. Once it is passed, then the court will pass an order to file you an amended writ petition. Amended writ petition will again have the same which you are going to file. Otherwise,
Yes, your lordship.
then why you are going through this long drawn process? Or the third option available. This court is not sitting from 21st till 2nd. you may take that advantage of convincing another judge who may be more kind to accept your submissions. Third, many lawyers have done it. So I also give you that option, otherwise it would amount to a violation of Article 14.
Your Lordship, we will always want to be before you when we are arguing this
Yes,
matter.
right. But the fact remains this, how do I take care of the read down of circular if it is not there? The challenge to the circular is not there. One has to read down to say that yes, this circular is there, it's okay. But this circular would not take away, however, the right of the authorities to consider, because one has to touch on the circular.
Yes, yes, Your Lordship.
Otherwise what happened? The problem you find many judgments of the Supreme Court also saying, and there are many judgments of the High Court also saying that the circulars are binding upon the officials. So as of now, he has done as per law, as per the circular. Yes, Mr. Betalau, what do you have to say? Kindly provide more aids to your learned friend.
Lordship, better we come up with a withdrawing this petition, but we would file it challenging the same
I think
notification.
that problem is being solved. Once you come up again, I'll give you the liberty. You need to challenge the circular, and then you challenge it and file a fresh one. So this formal defect is removed so that what happens at the end of the day, the school can very well pass an order to the effect that the circular is not, I can't say it to be directly or mandatory. No, the question of directly mandatory does not arise. The circular has to be read down.
Right.
To that effect that, look here, this is the circular which.
Whether put advance our arguments on the point about whether this notification, whether it's in contravention to the main act, whether the provisions.
You can raise everything.
No, that's
Prima facie, Mr. Bedala, you cannot say that this goes against the act. But the fact remains still that if a person is in extreme necessity, or there are good reasons for which he could not approach the court under 36 or file an application for compounding under 36, can the circular be made the basis on which that right be curtailed? And that can be then only be decided on the basis of a challenge to the Supreme Court. And have to say that, yes, the circular is okay, but then also you cannot. But can that be decided here?
the absence of that challenge being made. Would not be, because my lord cannot do until unless that has been impugned. To delve into that aspect of the matter,
problem.
that is, to delve into that aspect of the.
What do you say, madam?
Your Lord, Your Lord,
21st. Try your luck.
Your Lordship, we will refile the petition with challenge to the circular, and we have also challenged on various other multifold grounds. But that I think we will get
But whatever may be, the reason which is being given in that order is based on the circular.
Yes, Your Lordship.
So the circular cannot take away the right of a person. It's a different
Yes.
thing, a circular could be duly applicable to or it would be binding on the authority, but that cannot take away the right. That
Your
might
Lord,
be a big
Your
one.
Lordship, yes, Your Lordship will have to decide that the provision of limiting a time period for filing compounding, whether that is in contravention of the provisions of the Act.
So then the circular comes into the picture.
Yes, Your Lordship.
Miss so-and-so, the learned counsel appearing, and you take all these things, these will be helpful at a later stage. Miss so-and-so, the learned counsel appearing on behalf of Miss so-and-so and Mr. so-and-so. the learned counsels appearing on behalf of the petitioners in the instant petitioners. And also heard Mr. S.C. Kaya, the learned counsel appearing on behalf of the Income Tax Department. The petitioners have challenged, have the petitioner had petitioners, petitioner or petitioners?
Petitioners.
Petitioners have challenged the rejection of the application seeking compounding by the Principal Chief Commissioner of Income Tax, NER, Guwahati. For the financial year dated to, all dates are same,
All dates are same.
dated 31/1/2024. For the assessment financial year 2015-16, it is silent.
Yes, yes, your lordship.
7/8 of 2022, 15-16, okay, এই গোটেইকেইখনত আপুনি পাব page 82. It is apparent from a perusal of the said impugned order that the said order is passed on the basis of a circular issued by the CBDT dated 16/9/2022, whereby the Principal Chief Commissioner of Income Tax, NER, Income Tax, was given the power to relax the period up to 36 months. After carrying out certain hearing, after hearing the parties, the counsel appearing on behalf of the petitioner submitted that the petitioner would be well advised to withdraw the instant writ petition and file a fresh one by challenging the circular along with the circular dated 16/9/2022, along with the impugned order of rejection of the application seeking compounding. Taking into account the above, this court closes the instant writ petition on withdrawal. However, petitioner is granted the liberty to refile by challenging the circular dated 16/9/2022, as well as the impugned order dated 31/1/2024.
Your lordship, if you may grant a stay on the proceedings arising out of this order until the petition is refiled.
Madam, my jurisdiction was only limited there. How can I grant a stay in respect to a proceedings which is not there before me?
Lordship, we have also challenged the proceedings which have arisen out of my prosecution proceedings, and I have also challenged the sanction order which has initiated the prosecution proceeding. That is also part of my challenge, and hence there are multiple grounds to it.
You have
So
all
the-
liberty out there, but if the writ petition is not before me, how can I grant a stay?
Very well, your lordship, I'm obliged.
Hello.
It- Yes, Mr. Virajpur.
I received the instruction, Your Lordship. Order has been passed and Hallman committee has been appointed here. That is what.
heard Mr. T. N. Srinivasan, the learned, S. Chauhan, the learned counsel appearing on behalf of the petitioner, and Mr. V. Rajwa, the learned counsel appearing on behalf of the Corporation Department. The petitioner herein have challenged the action, the order dated 30/8/2024, passed by the Additional District Magistrate Morigaon, whereby the proposed election, which was duly notified, of the Baranga Bari Samabhai Committee to be held on
To be held on 15/9.
on 15/9/2024 was stalled, thereby stopping, thereby
Stopping
then
comments.
thereby withholding thereby directing that the nominations to be held on 5/9/2024 be stopped. To stop. It is relevant to take note of that that Barangabari Samavai Samiti is a cooperative society with it registered under the provisions of the Assam Cooperative Societies Act 2007. The said a perusal of for short, the Act of 2007. A perusal of the said the provisions of the said Act shows that the powers have been conferred upon various authorities. However, there is no power conferred there is no power conferred upon the additional district magistrate in terms of the Act of 2007 to intermingle with the functioning of a cooperative society. Intermeddle. It is also said that it is the register of cooperative societies or the officers who have been permitted by the register of cooperative society who can take appropriate steps in respect to the regulation and functioning of a cooperative society. Under such circumstances, it is also pertinent to mention herein that the society in question, in its meeting held on 15/8/2024, had finalized that the annual general meeting as well as the elections would be held on 15/9/2024. This aspect of the matter have also been approved by the Assistant Register of Cooperative Societies, Morigaon. In accordance thereto, notice was issued on 13/8/2024 thereby putting thereby setting in motion the election process. To be held on 15/9/2024. The nomination date, the last date for submission of the the date of nomination was also mentioned as 5/9/2024 from 10 a.m. to 1 p.m. What is the meaning of this? Accepting of nominations dated 5/9 Iman from Iman and submission of nomination. What is the difference between the two?
Lord, Samit Bhasan India,
No.
মনোনয়ন পত্র গ্রহণ 5/9/2003 প্রায় 1 বজালৈ মনোনয়ন পত্র দাখিলৰ শেষ সময় 2টা বজালৈ
No. What is this? Number 4?
Number 4 মনোনয়ন পত্র মাসুল
Means scrutiny. Ah. That is why I am not understanding the scrutiny of the nomination. Under such circumstances, in the opinion of this court, the additional district magistrate could not have exercised the power in terms with the order dated 30/8/2024. Accordingly, the said order is set aside and quashed. It is also very pertinent to take note of that on account of not holding the AGM within a particular period of time, within the term of the cooperative, within the term prescribed under the Act of 2007, certain disqualifications accrue upon the board of directors. Isn't it? It will be seen that
My lord, one correction was made by the authority, my lord. First, they passed order on 30/8. Where did they realize, my lord, that 5/9 order cannot be stayed, my lord. Thereafter, by erasing the corrected, the date 5/9/24, it is page 36.
I think at a 38 and 5/9 both set aside and passed. And certain disqualification ensures upon the board of directors. Taking into account that an authority, it is on account of an authority having no jurisdiction who had interfered with the process, election process. This court observes that the board of directors, the shareholders who were the board of directors of the society in question during the period from
My lord, my lord statement that 29/9 was the last date.
from when? 5 years will be from when? During the period from 2024, from 2019 to 2024.
Yes.
From 2019 to 2024. Shall not incur any disqualification on account of not holding the AGM within the time prescribed under the Act of 2007. With the above observations and directions, the petition stands dismissed. This court also further takes note of that pursuant to the completion of the term on 30/9/2024, a one-man committee was appointed on 1/10/2024 by the Register of Cooperative Society, isn't it?
Third of it.
On 3/9,
It
on
is
3/10/2024. By the Register of Cooperative Society,
by the Lordship Zonal Joint Register of Cooperative.
Zonal Joint Register of Good stuff. The said power which is to be exercised by the one-man committee is in terms with section 41(6) of the Act of 2007. And as per the said provision, the requirement of holding the election is within 90 days. 3 months or 90 days?
90 days from the date of such appointment.
From 90 days from the date of such appointment. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. Number one, the orders dated 38/2024 as well as 5/9/2024 passed by the additional district magistrate Morigaon is without jurisdiction and accordingly set aside and quashed. Number two, the petitioner's hearing, the board of directors of the society, that is Borangabari Samabhai Committee, during the period of 2019 to 2024 shall not incur any disqualification on account of not holding the elections within the time permitted under the Act of 2007. However, the said shall not mean that however, the shall the on account of me. I think this is clear enough. No? Number three, the one-man committee so appointed by the order dated 3/10/2024 is directed to complete the election process within 90 days from 3/10/2024. According to
28.
Mr. H. Sharma, you are appearing in that matter. Mr. H. Sharma Nambohai Degree appears for the additional distribution.
This case Lordship directed us to obtain the instructions once. Why this order of the commissioner is not complied with. Lordship, this is the instruction on 12th of September 2024. A letter was written to the Secretary of the Government of Assam Food and Public Distribution and Consumer Affairs, whereby it stated that the district commissioner, he doesn't have got the power of review against the order where the cancellation order was passed at the approval of the district commissioner. Accordingly, appeal lies. Accordingly, the application submitted by them is sent to the appellate authority. Appellate authority is the secretary to the Food and Public Distribution and Consumer Affairs Department. So it was sent to them with a copy to the insert secretary to Messrs.
So the appeal lies to the secretary,
Yes,
not to the commissioner.
no, he doesn't have got the under section,
So
under
you
order
say
29
the
1C.
commissioner has no.
Hold on.
So that order has is not nothing to do.
And on 39, the Lordship has passed order taking instruction from the commissioner also. My lord, we filed representation.
No, I never asked. I only asked to the from the district administration.
39.
39 order is very clear. Paragraph 4. Mr. H. Sharma, the learned counsel appearing on behalf of the district administrator, shall obtain appropriate instruction as sought for by the order dated 11
Sorry, my lord. 11-9 order.
11-9, what did I say? Mr. So-and-so appearing on Iman from the shall obtain necessary instructions from both the Food and Civil Supplies Consumer and Meteorological Department of the government as well as the district commissioner.
That is one.
District commissioner, he is appearing, na?
Yes, my lord.
This is being given by district commissioner. The district commissioner therefore says has submitted a petition to the undersigned in connection with the withdrawal as well as refunctioning of the so-and-so. And so-and-so as per the placing the Iman. The PDS license of so-and-so was cancelled by the then licensing authority after taking approval of the district commissioner. Karimganj, after observing all formalities such as so-called notice opportunities for reasonable hearing, personal hearing. Papers are so-and-so. In view of the above, the matter is hereby sent to as appellate authority as per clause 29(1) of the Iman in favor of your perusal.
This appellate authority is the Secretary to the Government of Assam, FPD and CA Department.
Where is it mentioned?
Lordship, it is mentioned in 29(1)(c). 29(1)(c), it was the Divisional Commissioner. Thereafter, as because Divisional Commissioner is no more there, Lordship.
No,
accordingly,
wait. Earlier, who passed the order?
The order was passed at the approval of
19-7 order, my lord, annexer. Page 34, my lord.
Huh?
Page 34,
cancellation order.
cancellation order.
No. Who has passed that? Commissioner order is where?
My lord, page 62.
This was not. This was passed on 6/3/2024.
Yes, ma'am.
On that day, the commissioner was there or not? This is being done by the Commissioner of Food and Civil Supplies. Does he have the power or not?
Lordship, the cancellation order was passed at the approval of the District Commissioner. Cancellation order, if you remember, given.
No, that is okay.
Lordship.
He had filed an appeal. He said that the appellate order was passed by the Commissioner, Food and Civil Supplies at page 62.
Lordship.
You say that the Commissioner has no power.
No, not the commission, District Commissioner, as because he has sent this matter to the District Commissioner.
Your
If
basic case
your
is
lordship
that
come to
this
page
is that-
62,
No. First of all, whether this authority who passed the order at page 62
yes.
has the authority to pass this order or not.
No, he has sent this matter for reinstating or issuance of fresh license.
So he's asking, he already,
Yes, as
no,
because-
first therefore, my specific question therefore is whether this Commissioner of Food and Civil Supplies have the power to take on appeal against an order of cancellation of a PDS license.
The secretary has got the power of to take up the appeal,
Not the Commissioner.
not the commission.
What is your basis to say that? Then why was his appeal filed against them?
After filing appeal, my lord commissioner has got report from the deputy commissioner. Deputy commissioner also furnished report to the commissioner. My lord, at page 56. And report is at page,
I have received.
page 54. And on the basis of the report of the commissioner, deputy commissioner, my lord, the order was. After-
Understood.
Yes.
But the question is whether the Commissioner Food and Civil Supplies, you see, there is a difference. What was abolished was not the post of the Commissioner. What was abolished is the post of the Divisional Commissioner.
Yes, ma'am.
So the Divisional Commissioner's all role has now been given there, but or is it the Commissioner's role? Post has been here. Is there?
As I have been told, it is the secretary who can take up the appeal.
From
as an
where?
appellate authority.
Where?
This is an order of the governor, it's a notification dated lordship 16/11 to 23.
So this
Not
was
very legible lordship, but even then.
16/11/2023.
Lord.
So 16/11/2023, that means this order has no, without jurisdiction. In view of the abolition of the post of Commissioner of Divisions, Government of Assam, to delegate the following subject matter mentioned below to the Food Public Distribution and Consumer Affairs, the erstwhile Divisional Commissioner was the appellate authority. Now, subject matter bill as per ARDA Order 82, transferred to the Department, Food Public Distribution. For the decision taken, the meeting of the shall take necessary steps to concern the commissioner, which bring the custody of the file to me. No. What they have done is this. In view of the abolition of the post of the Commissioner of Divisions, the Governor of Assam is pleased to delegate the following subject matter mentioned as below to the Food, Public Distribution and Consumer Affairs Department. And then the erstwhile divisional layer with the appellate authority as follows. So now it lies to the food, public distribution and why you are mentioning as the secretary?
I have been told like that. When
No, you can't be saying that.
amendment,
The notice has been issued with reference to the minutes of the meeting held on so and so and under the chairmanship of the chief secretary and subsequent approval of the honorable chief minister. Where is the power to hear? They have been given
when
to
I
the food
inquired,
public
Lordship,
distribution. Now there is a post of commissioner. Food, so it has been transferred to the department.
yes. And
So
when I
now therefore,
inquired,
why you are saying that the secretary?
when I inquired that as who is this appellate authority, I have been told that it is the secretary. Then I asked for where from you get it. So from their office, this letter was sent to
But
me.
this doesn't-
I
that
have
is
seen
so.
that it's transferred to public food and distribution.
So if that is so, if the post of commissioner is there, it can be anybody.
Commissioner
In any person from that department doing
Probably,
even,
probably the secretary is taking up the appellate matters.
how do you say? Unless they specifically says,
There is no such specific, as because this, the authority is given to the department.
And in the instant case, my lord, commissioner has acted upon.
No,
Without
Commissioner has not acted upon. From the
He
letter,
has
he
passed
doesn't
the
reply.
order.
No,
And he inquiry report is also there, my lord. Lordship
it
kindly.
is not that the matter has been remanded back. It is not the matter of like that,
My lord, the inquiry report is page 53.
is of the opinion that the district authority will take necessary action regarding reinstating. Means that he has approved. You see, what he has done, he has allowed his appeal. But the question arises as to whether the commissioner is the appeal.
but I have been told like that,
No, you
secretary.
cannot be merely told, you file an affidavit. Can't help you, without that affidavit, it is not. Because in my opinion, anybody, even I think the peon of food and civil supplies department can also
It seems
pass
to
the.
be like that, Lordship. It seems to be like that from that
And
notification.
one interesting aspect is that, my lord, the cancellation order was issued on 19/7 and page 45, lordship kindly see. Page 45, annexure A. The notice was issued, before that, no notice was issued to the, my lord, society. Only on, my lord, 12th of September 23, my lord, notice was issued to the, my lord, society. Before that, no notice, cancellation in July and notice in, my lord, September.
Okay, let them file an affidavit.
Lordship.
Pursuant to the instructions, pursuant to the order passed by this court on 30/9/2024, an instruction have been placed by Mr. H. Sharma, appearing on behalf of the District Commissioner, Karimganj. On the same instruction, the query which have been made by this court on 11/9/2024 does not appear to be clear, appear to be clarified. Be that as it may, Mr. H. Sharma submits that it is that the appellate authority to hear appeals against orders passed under clause 15. 15,
Appellate 29C.
to hear appeal against orders passed under 15, na?
Lordship.
15 of the Assam Public Distribution of Articles Order 1982 is the secretary to the government of Assam would
The food, civil supplies,
civil supplies, consumer affairs and legal metrology Assam department.
food public distribution and consumer affairs department.
In that regard, he has placed before this court an order, a notification dated 10/11 to 16/11/2023. However, the same does not does not prima facie appear to be conferring such appellate authority upon the secretary. Be that as it may, these aspects would require an affidavit to be filed by the respondent authorities. Accordingly, list this matter again on 18th November. The affidavit be filed by 8th of November by the respondents. The petitioner thereupon shall be at liberty to file the reply. Who are you? Corporation Department, what the business is here? Oh, you have unnecessarily.
My lord, some of the documents have annexed pertains to my lord corporation department.
So and so appears for the. You want to file affidavit?